So, and I'll go through, this is a live stream on YouTube. Let me go and check and see, make sure it should be live already. Yep, it is. Um, so, um, so this is called appealable issues. And those courts are not interested in justice. They're Roman courts, they're Roman cult courts. They're interested in selling people into slavery, is what they're interested in doing. And if you hire a lawyer, then you cannot challenge jurisdiction if you have a lawyer. Anyways, first of all, I'm not a liar. Well, I meant a lawyer. No, I meant a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything. I'm an open to any ideas. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves, and there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? And that's what I see all the time. I help people in the courts all the time, and I see people that have basically given up their rights. And, they tell you right up front, they say anything you say can and will be used against you in a court of law. And, they're not lying. That's exactly what they're going to do. And so when you go and give up your rights, then you give them up. Never forget, the men who started this country are marijuana growing, whiskey drinking, tax evading rebels who left their beds at night to shoot at the cops. And I mean, that's what they were. Think about it. And so all tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical, pharmaceutical, industrial complex, owns the military industrial complex, and owns the mainstream media. And if you call me a conspiracy theorist, I don't trust you. I forgot to start this thing recording, so let's get that started too. Although I am recording it online. So on my, there we go, it's recording. So yeah, this software here records it too. So it's getting recorded, fortunately. That's a brand new camera, so I'm still, that's in a work in progress. I just adjusted some of the settings in it, and so if it makes a noise, it's shutting down, and I need to change the SD card. So if somebody hears something, let me know. Okay, I should hear it. I turned the volume up on that, so hopefully I'll hear it. Government's not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. So there's a thing called the law of the case, okay? And it's similar to res judicata and stare decisis. The law of the case doctrine provides that an appellate court's determination of a legal issue binds both the trial court and the court on appeal in any subsequent retrial or appeal involving the same case and substantially the same facts. So remember, they're talking about the appellate court, okay? In the lower court, they're not interested in justice. They're selling you into slavery is what they're doing. The appellate court's holdings on the questions presented to it on review become law of the case. So it's the lower court doesn't mean anything. And so it's the Court of Appeals that's going to really make a decision. And their job in the Court of Appeals is to maintain the case law. They have to follow the law. You have to bring the right issues to them. And that's why you have to set up appealable issues. The purpose of the doctrine is to promote finality and judicial economy by minimizing unnecessary relitigation of legal issues once they've been resolved by the appellate court. Cases such as this one from Indiana explain that the law of the case doctrine precludes relitigation for all issues decided directly or by implication in a prior decision. However, the court notes that where new facts are presented upon demand that materially affect the question at issue, the court upon remand, when new facts are presented upon remand that materially affect the question at issue, the court upon remand may apply the law to the new facts as subsequently found. So remand means they remand it back to the lower court. Okay, so when you go to the Court of Appeals, depending on what the Court of Appeals rules, okay, they might say that there was an improper trial, like with Dr. Joe. Okay, you know Dr. Joe. He was tried on a felony, and they had him in their jail. He went and he filed 14 challenges to jurisdiction before he had a lawyer. Okay, he did it himself, and they ignored them all. Matter of fact, they dismissed them all on the same day. Anyways, so what happened is then they held their show trial and they sold him into slavery, and then he hired a lawyer, and the lawyer brought it up in the Court of Criminal Appeals about these 14 challenges to jurisdiction. And this is a landmark court case in Texas now. It's called State versus DeRusso. And this is a huge court case that's become, and where the Court of Appeals said because he filed these 14 challenges to jurisdiction, they never acquired jurisdiction. Okay, number one. And number two, there wasn't a crime. Okay, so he had been charged for something. The charges were bogus. Okay, they were bogus. There was no crime. He hadn't done anything that was a crime. And so they basically, the Court of Appeals threw the lower courts under the bus. So now Joe he's not a lawyer. He's got Randy Kelton working on it, and hopefully Randy can sue him. But it's a huge job. And just because he has a case like that, it's not a foregone conclusion, Anyways, they threw him under the bus, and it's actually become a huge landmark case in Texas. So that's the important thing. Okay, he got those appealable issues because those 14 challenges to jurisdictions what saved his butt. Otherwise, he'd still be in jail right now. Okay.
Would the appeals court have taken the case based on the fact that there was no crime? And would they have ruled the same way, or were they held over a barrel because he already filed jurisdictional challenges that weren't properly adjudicated?
The appeals court's job is to maintain the case law. So if there's something that's improper, then they're the ones that are supposed to point it out. Okay, that's their job. But he had already filed it. Like there's a court of appeals. He'd have filed it in the Court of Appeals, and they had ruled against him. And then he filed it. He appealed that to the Court of Criminal Appeals, which is equivalent to the Supreme Court in Texas. And they're the ones that went and vacated. They vacated the whole thing. But what they did is they remanded it back to the local court. And they said that because all they did is they say that it was a void judgment, and they vacated everything and they remanded it back to the local court. And so then the local court, they decided not to pursue it. Okay, and so anyways, they tried to get him to plea bargain. Okay,
after the fact?
No, before. And he refused to plea bargain because he couldn't see how he'd done anything wrong.
Yeah.
And if you plea bargain, you got to understand, if you plea bargain, that's a contract, and then you're screwed. You can't appeal a plea bargain. You see what I'm saying?
No.
And so anyways, it was quite a fiasco. But you have to understand, it's the law of the case, okay? And the law of the case comes from the appeals court, okay? You have to set up your appeals. That lower court, it's really not a court, okay? Even the appeals court is not. We're going to go through that. But the point is you have to challenge, have to bring up the appealable issues. And there's a bunch of ways you can do it. And if you do a good job of it, you might be able to get it dismissed before it even goes to trial. Okay? Because the juries nowadays are a bunch of idiots. Okay? You're not going to get trial by jury. You can, if you challenge it at the right time and in the right way, you might get it dropped at that point. Okay? But if you go to a jury trial, they're a bunch of idiots. Okay? It's not a trial by jury. You know, don't get me going. You're going to get me going. So you absolutely have to set up the appealable issues. If you do not appeal, it becomes essentially a contract, and you agreed to it. Courts of appeal have a duty to maintain the case law when the issues presented are the right ones. So the whole purpose of everything you do in there is to set up the appealable issues, and because there's no justice that's going to go on in that court. So attorneys, this is about attorneys too, because he is, however, in a sense, an officer of the state with an obligation to the court. This is Book 7 of Corpus Juris Secundum, Section 4, Attorneys. Corpus Juris Secundum is about 150-volume set of books in the law library that talks about, that's the second law. Okay, that's what secundum means, Corpus Juris Secundum, the body of the second law. His first duties to the courts and to the public, not to the client. Okay, whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. That attorney's not working for you. Okay, he's going to sell you into slavery. You hire an attorney, then you can't even challenge jurisdiction. Clients are also called wards of the court. So you're basically throwing yourself at the mercy of the court when I hire that attorney. That's a major mistake, in my opinion. In my opinion. Wards of the court are infants and persons of unsound mind. And so a ward of the court is an imbecile. Okay? If you hire an attorney, you're an imbecile. You're saying, I'm an imbecile. A ward of court is not competent. Everything's about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney's going to make the decisions for you, and he's going to sell you down the river. He's working for the judge, and the judge wants to make a bunch of money, and he's going to get commissions and royalties and all sorts of stuff off that case. There's no such thing as an incompetent sovereign. Do you know who you are?
So how does assistance of counsel work with the sovereignty versus ward of the court?
I'm going to get there.
Oh, okay.
Attorney's job is to make sure there's no appealable issues. They will tell you that. I've had attorneys tell us that, okay? Their job is to make sure there's no appealable issues. How do they do that? They do it three ways. First of all, they fail to object to the denials of due process of law. The Court of Appeals works on the record only, okay? If there's nothing in the record where you're challenging, there's court cases that say that if there's a fake indictment, if you don't object to it before the trial, then you can't object to it after that, okay? And they have fake indictments all the time, okay? So there's court cases that talk about that stuff. If you don't object to these denials of procedure, okay, before the trial, then you can't object to it after that. And so they failed to object to the irregularities in the procedure, and they testify against you. They actually testify against you. The prosecutor does it, and so does your own attorney, okay? They do it all the time. There's a guy in Texas, his name is, he had Mulligan Mint, okay? And his name is, he has a Texas coin. And Mulligan Mint was, they were making OACS, or American Open Currency Standard coins, gold and silver coins and copper coins. And you can still, those coins are still around. You can still get them on eBay and stuff like that. But that Mulligan Mint is shut down. Anyways, he had to go bankrupt, and that was like major mistake. And so when he went bankrupt, he had to go and file bankruptcy in the court. And the attorney went and told the judge that he's an alter ego, and so they pierced all of his corporate structures, and then they went and forced him, they went and seized everything, and he wound up with nothing. and that's the attorney did that. They do that stuff all the time. An alter ego is basically that gives them an excuse to pierce it. Like if you have a trust or something like that, they just say, "Oh, it's an alter ego." You know what I mean? And they'll pierce it. And so you gotta make sure you have your I's dotted and your T's crossed. Anyways, they testify against you. How do they testify against you? First of all, they admit the jurisdiction. Okay, you cannot challenge jurisdiction if you have a lawyer, and they enter pleas for you, and you don't even know that's what's going on. Okay, they falsely accuse you, and they do that all the time too. They routinely continue cases, thereby denying your right to a speedy trial, and that's true. All they have to do, you have a right to a speedy trial, but if that case gets continued for any reason, well, you just threw out your right to a speedy trial, so they can sit there and drag it on forever, and you're screwed. And they do it, and they don't tell you they're doing it. Impropriety persona, in one's own proper person. It is a rule in pleading that pleas to the jurisdiction of the court must be pled impropriety persona, because if pleaded by attorney, they admit the jurisdiction. As an attorney is an officer of the court, he's presumed to plead after having obtained leave, which admits the jurisdiction. Okay, so if you have an attorney, you can't plead no jurisdiction through an attorney. You got to do it yourself. And so Joe filed those 14 challenges to jurisdiction before he had an attorney, and that's what saved his butt. How did the prosecutor and your own attorney falsely accuse you? Well, so it goes to their rules of ethics. Okay, under the rules of ethics, they're not allowed to make false statements against you, but your only remedy is to object to their false statements. But if you don't object to their false statements, then they're admitted as the truth, because they're not supposed to make false statements against you under their ethics. You see what I'm saying? So they just make a statement. If you don't object to it, it's admitted as the truth. So you have an attorney. If you have an attorney, you're not even allowed to speak. Because of their rules of ethics, any statements they make that are not objected to are admitted as the truth, because you and your attorney admitted them by failing to object. Yes?
If we're not allowed to speak, how can we object?
Good point. That's why you object to the attorney. And make sure it's in writing all over the place. It's a star chamber. Absolutely. I agree 100%. It's a kangaroo court. That's why I say they're not interested in justice. They're selling you down the river. That's what they're doing. Don't get me going. You're going to get me going here. These so-called courts routinely engage in numerous denials of due process of law, which relieves them of subject matter jurisdiction. But you got to point it out. If there's anywhere you'll get your rights violated, it's in these so-called courts. Guaranteed. I always file bar grievances against all bar members. I always file judicial complaints against all the fake judges. And when I file lawsuits, the state bar gets named. In my recent lawsuit in federal court, I tried to name the State Commission on Judicial Conduct. What happened is I filed a first amended demand for relief. And under the rules, you're allowed to file one. And then when I went to file a second one, the judge wouldn't allow it to be filed because you have to get permission from all the opposing counsel. And they wouldn't agree to it. So I tried to do all sorts of things, and they wouldn't agree to it. So that's I'll learn. Next time it won't be the first one will be the real one. Or I'll try and make sure the first one, the original demand for relief, is good to go. But you have to be careful, because if you bring up issues that they don't want to talk about, then they might dismiss the case. Okay, and so that's why in the first one I didn't bring up some issues, but the first amended demand for relief is the one that you have to make sure and really make it powerful. That's the federal courts. Okay, I don't know about state courts. I mean, I can't tell you off the top of my head. But in federal courts, that's the rules in the federal rules of civil procedure.
What level bar grievance? I mean, what can you bring up? In case of
Everything.
a bar grievance?
They're testifying against you without authority. They're making false statements about you. I bring up everything. Okay. And matter of fact, I usually like to bring up criminal complaints. I'll file criminal complaints against them. Okay. For there's all sorts of felonies they engage in. Barratry, okay, representing you without authority. There's all sorts of stuff. Okay. So any lawyer, I'll start filing criminal complaints against them, and then I'll use the criminal complaints as evidence for the bar grievance. Of course, the bar are going to blow it off. I filed bar grievances against 95 different lawyers, some of them more than once. That's what I brought up in my federal case, and they dismissed them all as an inquiry. And so, but now that I'm suing the state bar, I guarantee you, when I file another bar grievance, we'll see what happens. But and I'm in the U.S. Court of Appeals for the Fifth Circuit, and I'm prepared to take it to the Supreme Court. That's not a problem, and I've been there before. And so when Montague County started doing the shit they were doing, I told them, I've been to the Supreme Court 5 times, and you're next. You know how much it costs to go to the Supreme Court? It's not going to cost me anything. I probably won't even pay filing fees. And you know how much it's going to cost? It's going to cost them way more than they can possibly imagine. And it's probably going to cost them $50,000 if it's a nickel to go to the Court of Appeals. A nickel, maybe $100,000. It'll cost them to hire lawyers for the Court of Appeals. I don't know, and I don't really care. I'm entitled to appeal it, and I will, and I am appealing it.
It's a whole hell of a lot less than what they took you to court for.
Sorry?
It's a whole hell of a lot more, I should say, than what they were taking.
Yeah, they're a bunch of thieves. And the federal court, when they dismissed my case, they dismissed it without prejudice. They're essentially telling me that if I bring up different arguments, I can bring the action again. And so they're saying that I have a valid case. Anyways, yeah, don't get me going. You're going to get me going. These Montague County thieves and their bar member scum, don't get me going. They hate bar grievances. A friend bar grieved his own public defender. This is a little strategy. Okay, this is a little strategy. Randy Kelton tells this story. The public defender was in court begging to get off the case. If you bar grieve them, they hate bar grievances. Okay, so this public pretender was in court begging to get off the case, and the judge always has to ask the defendant if he wants the public defender off the case. And so what Randy said he did is he said we're under a private contract. The court can't interfere with a private contract, and so we're under a private contract. I want him on the case. I want him to do his job. And so the judge said, you're stuck on the case, told he was to remain on the case. And then as he was leaving the courtroom, he went and told him, he said, you better get this thing just dropped or dismissed or something, because otherwise I'm going to bar grieve you again. And 4 hours later, Randy got a phone call from the public pretender. He was all excited. The case got dropped, and it's the first case he ever won. This is what they do. I'm telling you, you're not going to get justice unless you're prepared. What you have to do, number one, is you have to give him plausible deniability in front of the judge, okay? Because he's working for the court. He's going to sell you down the river for the court, okay? And so if you go and do that now in front of the judge knows that now this public pretender has to actually work for you and have to do things for you. You see what I'm saying? And so he can't hold it against the lawyer for doing things for you. You see what I'm saying? And so otherwise you're going to get sold down the river. That's what they do. There's nothing there to do with justice. Okay, they're nothing but a bunch of thieves. Okay, don't get me going. So I've got exclusive content available on HowTube. It's $9.99 a month for videos plus unlimited email consultations, but I'm not a liar. Well, I'm an attorney. No, I'm a liar. But I can't tell you what I would do and where to find the forms. The only power that the New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. Some of my exclusive content is an Arlington private information share, land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration, criminal complaint training. I got about 3 videos on that. I probably should do another one. Lawsuit training, I got 1 video on that. And I probably need to do more, but I haven't. Other training or requests, I'm available. If anybody has any ideas on types of training that I can do, I'm open to ideas, but it has to be something I haven't already done, and it has to be something that's within the scope of what my channel is all about. And so, about the law and that kind of thing. And so, Northeast private information share videos, a lot of them go up there. Some of them are public. I need to do one for a petition for writ of mandamus. Again, that's what this video is about laying a foundation for the mandamus, okay? And about appealable issues. And if you do it right, do it well, then you can actually get the case dismissed or dropped before it even goes to trial. But they like to drag it on, and they like to assault you with their liars, and yeah, don't get me going. Anyways, videos taken down by YouTube are up on the exclusive content, and that's on HowTube. There's first views of all new uploads. All forms, files, and other instructions are available for free, linked on my videos and on my website. I have exclusive content, will be on howtube.com, and you can buy a subscription there. Now, I don't have any control over HowTube and how they do their buy the subscriptions. Okay, I've actually got exclusive videos available on my website, but there's not near as many on my website, and those videos that are exclusive on my website are actually on YouTube. They're listed as private videos, and so you can watch them on my website. But HowTube has way more videos. There's like over 100 videos on HowTube, and the ones on my website there might be 20 or 30 or 40 at the most. And so and I'm trying to move everything away from my website, but there are people that have subscriptions on my website, and they also the people keep buying them. so I can't stop them. And so but the HowTube videos, there's way more there. There's all of the videos that are exclusive on my website, and then plus a bunch more that are on HowTube. And so that's and also I also have a subscription on my YouTube channel now. YouTube has all of a sudden monetized my channel, okay? And I think it's because I don't know. I'm threatening to sue them. I put it in the show notes. YouTube and Alphabet want to be sued. They've taken my channel down twice, and so they want to be sued. So they have actually taken my channel down twice. When they send you an email, when they take your channel down, they send you an email. We took your channel down, and if you got something to say about it, you can respond to it here. And both times I responded the same way. I said, you're engaged in multiple felonies. You're violating my rights under the color of law, which is a felony. You're conspiring to threaten, coerce, injure, intimidate me in the free exercise of my rights, another felony. You're engaged in war crimes with your forced medical experiment, and you're taking reprisals against me for my political beliefs, and you're subjecting me to your Satanism with your sorcery and your fraud and lies and deception. And I'm going to sue your butt off. All your executive officers and board of directors are personally liable in their private capacity. Don't think I don't know what to do because I've been to the U.S. Supreme Court 5 times. You're next. And 15 minutes later, my channel's back up. So, but I said I put it in my YouTube in the show notes. The first line is YouTube, Alphabet, Google, and Alphabet and YouTube want to be sued, and I'm going to sue their butt off because they've taken my channel down twice. And they've demonetized it. Now it's monetized. They just monetized it here like about 3 days ago. And so I set up a couple subscriptions. I've actually got one subscription for $19.99 a month you get free admission to the Northeast Private Information Share events, and so that's one of the. There's 2 subscription levels. Anyways, so that's available on YouTube. Not every action by any judge is an exercise of his judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when the judge does not follow the law, the judge loses subject matter jurisdiction. And the judge's orders are void, of no legal force or effect. And so you got to understand that. They have to have, if they lose subject matter jurisdiction, then they're screwed. They don't have any kind of jurisdiction. They have to have jurisdiction over your person and the subject matter. And it's easy to defeat the subject matter jurisdiction. The in personam jurisdiction, that's a little more difficult. I mean, they assault you, you show up, then you're giving them jurisdiction. And so the subject matter, though, is easy and it can be challenged at any time. Subject matter jurisdiction cannot be waived. It may be raised at any point in the proceeding. Because Andrea herself filed a motion to modify, alleging in pertinent part this court is continuing exclusive jurisdiction of this suit, it could be argued that she made a judicial admission that the trial court has subject matter jurisdiction or is a stop to deny the court's jurisdiction. However, subject matter jurisdiction cannot be conferred by agreement, nor can it be conferred by estoppel. If subject matter jurisdiction cannot be conferred by agreement or estoppel, then it cannot be conferred by judicial admission. Okay, so they cannot say we have jurisdiction. Okay, that's a bunch of crap. And so whether a pleader has alleged facts that affirmatively demonstrate a trial court's subject matter jurisdiction is a question of law reviewed de novo. Likewise, whether undisputed evidence of jurisdictional facts establishes a trial court's jurisdiction is also a question of law. Whether a court has subject matter jurisdiction is a question of law. Whether a pleader has alleged facts that affirmatively demonstrate a trial court's subject matter jurisdiction is a question of law reviewed de novo. Likewise, when undisputed evidence of jurisdictional facts establishes a trial court's jurisdiction is also a question of law. And so that's why you get it in there, you get it on the record, you're challenging jurisdiction. The statutory provision merely codifies the well-established principle that courts acquire authority to adjudicate a matter when they have both subject matter and in personam jurisdiction. Okay, they have to have both, and that's well established. And it's the minor estate. Okay, they're assaulting you with that minor estate. This is all Roman law. Okay, we're going to have another presentation that I'm going to go to, and it talks about Roman law and how these courts are all Roman law. And that's what I'm bringing up in my appeal, that it's unconstitutional because it comes from that 1871 corporation, and so that's all in my appeal in the federal courts right now. Individual means a natural person. A minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. That's in the Code of Federal Regulations, 31 CFR 363.6. And if you're subject to the regulations, then you are property of the government. Okay, so that minor estate is property of the government. Court means a court of law with jurisdiction over the parties and the subject matter. Okay, that's in the regulations too. Entity means any owner of a Treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company. Trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor, which puts you under the Commerce Clause. Okay, Article 1, Section 8, Clause 3. And under the Commerce Clause, you have no rights as the dictatorship, and you're in D.C. Without a formal and sufficient indictment or information, a court does not acquire subject matter jurisdiction, and thus an accused may not be punished for a crime. Okay, so again, you have to challenge that before the trial. That's what the courts have ruled in Texas, and the sooner you challenge that stuff, the better. You get it on the record, because then if you do challenge enough of that stuff, then you can go to the Court of Appeals and ask the Court of Appeals to order them to prove jurisdiction. And if you do that, that's what the mandamus is for. They're supposed to prove jurisdiction. And so you get the Court of Appeals to order them to prove jurisdiction. Well, if you do it well, then what the Court of Appeals will do is dismiss it, and the case is over. It's done.
Would you not even start challenging jurisdiction on the cops that arrest you in the very first place?
Absolutely, absolutely.
Territorial.
So yeah. So you start bringing what I do. Okay, and they don't want to talk to me. Ken sent out a text here. Let me find it. They have my car. They're using my car. Let me find it. Yeah, right here. Public safety, highway patrol. Isn't that interesting? Anyways, let me go back to the text. Ken sent out, just got pulled over. I have no driver's license or insurance. I told him I don't drive, I don't operate in commerce, and I'm self-insured. I gave him my common law passport. He gave me a warning, and I signed it without prejudice instead of my name. The warning shows my ID was a foreign government. Was foreign government issued. You need to get a common law passport. And so then, furthermore, there's all sorts of people saying, well, good job. It was for an illegal lane change. It was highway patrol. To make matters worse, I was in my car. He was in my car. I'm sure he ran the plates. Probably did. I'm sure he did. And the car is unregistered. Actually, it is registered. It's registered in Arizona. Forgot to tell him I was traveling as an ambassador for the Republic of Texas, Darren Swain. And I asked him which police stopped you, and he said public safety, highway patrol. Anyways, so he's got a common law passport from that the organization that you're familiar with. Mm-hmm. Anyways, yes.
His common law passport in the nationality box has just dashes. There's no nationality on the common law passport.
Oh, it's a foreign government though. So anyways, yeah.
It's him. He's the government.
Yeah, that's right.
And man, that's the common law.
There you go.
So that's the point.
I know. I tried to get some stuff from them, and their website blocks me for some reason. I'm not sure why. Anyways, so
don't use VPNs.
Maybe, hey.
VPNs is a killer to some sites.
Yeah.
I think I tried to access it when I was still connected to my VPN, and I got blocked as well. I realized very quickly what was going on, so turned it off, and then I was fine.
Yeah.
So maybe it was that.
Maybe I'll have to try it. Anyways, so fake indictment. Okay, an indictment has to say true bill. Okay, remember it's a bill of indictment. Okay. Matter of fact, there's at that last Tuesday, there was a guy that was talking about equity, and he brought up some good points. I wouldn't ask him for any help. I don't think under some circumstances I would, but I usually try and get it dealt with before it ever gets to the point that they're thinking they have some contract, and that's why I accuse them of attempted murder. But for anybody that's having to deal with child support or anything like that, I mean, you're in a contract, and now you're going to have to go into their venue to deal with it. And so then that guy will come in pretty useful, I think. But an indictment's supposed to have true bill. It's a bill of indictment. And matter of fact, he talked about motions, and he said it's not a motion. Motion is begging. It's a writ. You call it a writ. And so that's what I started calling all my documents a writ. And so it's not signed. I've seen indictments that weren't signed. I've seen in Dr. Joe's indictment, okay, the judge modified the thing. Well, that tells you it's not a valid indictment. If the judge is modifying the thing, all it is a criminal complaint. And under Texas codes, it has to be an indictment. So how do you prove it? I mean, that's difficult to do because grand juries meet in secret. They don't meet in the public. But there's the way you do it in Texas is you ask for the receipt. You do it as part of your discovery. You want a receipt for the court reporter for to show that there was a grand jury proceeding and they paid the court reporter for because they're supposed to do a court reporter for it. Anyways, that's how you do it in Texas. Yes.
Has anyone ever requested a receipt and got one?
No, because I think they're all fake. The indictments aren't fake. They're fake. They're not really having grand jury proceedings. They're lying to you. Anyways, I'll be right back to one thing about that T and one in and out the other, you know. So they never follow their own codes, okay? They never follow their own codes. You have to get to know their codes because that's what they're required to follow. Copies of these documents can be found on my website and linked under my recent videos. For a complete set of YouTube videos with private information shares, a DVD with over 100. Actually, it's a thumb drive. Probably ought to save that. With over 100 searchable law dictionaries and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the forced loans, I guess we can eliminate that. I said IOUs twice. The securities, the cash app gifts, the checks, the money orders, etc. Send me an email for particulars. If the record does not show upon its face the facts necessary to give the court jurisdiction, they will be presumed not to have existed. So my new book is available. Whoops. My book is now available, Trump, a True American Patriot or Not. Mike Blackwell asked me to write the book, it took me about 6 weeks to write the book because I just took a lawsuit and manipulated it and turned it into the book. But then Mike had to babysit me for about 6 months to get it ready to publish. So I put him on the book because, he babysat me through the whole thing. But I wrote the book. And it's 99% or 95% provable facts. I use court cases, law dictionary definitions, international treaties to prove everything I say in there. But he hired a company to help us publish it, and they wrote the back. This is on the back of the book, and I think it nails it. It says, in Trump, a True American Patriot or Not, Glenn Fern and Mike Blackwell reveal the depths of corruption, deceit, and manipulation infesting our political system for hundreds of years, regardless of political affiliation. Read the hard evidence that exposes how our elected officials sold Americans into slavery. Understand the Founding Fathers' true intent when they formed our Republican form of government. Discover the influence of the satanic Roman cult in our politicians and political system. Does Trump want to transfer power back to we the people? And Trump, you will see the great battle that is upon us. And I think they nailed it there. I think they really did. By the way, there's some pies there. If anybody wants a piece of pie, you're welcome to help yourself to one. Anyways, I probably need to open it up and cut it in pieces so then you can, easier to get one. Anyways, you can order the book from Amazon or from my website. It's $40 plus shipping. I prefer you order from my website. You'll get a signed or autographed copy. And my website, sovereigntyinternational.fyi. Do you want to know the origins of the deep state? Who's behind it? Do you want to know why it's called the Trump administration? Every word, everything the government does is they know exactly what they're doing. They don't do anything by accident. Do you want to know what an administration is? Do you want to know how Trump came to be president? He was invited. I don't know how many of you have heard of Jerome Corsi. He's a guy that lives up in the Northeast. He's written a bunch of books. He's got a website, a YouTube channel. He's got a PhD in political science from Harvard. He says that in 2015, 5 generals, there's a YouTube video where he says that in 2015, 5 generals came to see him and they said they were going to overthrow Obama. And he said, well, you can do that if you want, but you might want to go talk to Donald Trump first. And 3 months later, he gets a phone call. They decided not to overthrow Obama because Donald Trump had agreed to run for president. They say that there's actually about 200 generals that are behind Trump. And so, do you want to know who owns Congress? They're owned. That's why Nancy Pelosi gets up there and says, we can't read this bill until after we pass it. If I was a member of Congress, I'd say, okay, well, then it's an automatic no. I'm opposed to it. I don't care what it says. I'm opposed to it. Anyways, do you want to know why they're called law enforcement officers? Right there is the Law of War Manual, and it's full of stuff about law enforcement officers. They're here to enforce the martial law. You want to know how you have become a slave? You want to know if you're forced to work for the government for nothing, then you were a slave. Do you want to know what the root cause of the War of Independence was? It's in the book. It's the same thing that's going on now. You want to know why every president goes to visit the Pope on their first international trip? That's true. It's in the book. So I already told you about Mike Blackwell and Jerome Corsi and the 95% provable facts. My opinion is that all billionaires get approached by the New World Order crowd and they get told you're going to go along with our program or you're going to turn up dead. And I think that Trump was approached. There's a helicopter crash in 1984. There was 3 of his executives got killed. I started out working as a mechanic on helicopters in 1976. And so I happen to know a little bit about helicopters. And this helicopter crash, the blades came off, according to the news report. And I've never, ever heard of a helicopter crashing because the blades come off. I've heard of helicopters crashing because the tail rotor dry shaft bearings seize up. Matter of fact, as a mechanic, we were told they have temperature-sensitive paint on those tail rotor dry shaft bearings. And you're supposed to check them and make sure that paint is not discolored. If it's discolored, then that helicopter ain't going anywhere until you change that bearing. Anyways.
So what's different about Trump being approached as a billionaire by the New World Order crowd? Why is he not surrendering if that's the case? Or is he saying, fine, if you want to kill me? Like, how is he not surrendered?
Well, they tried to kill him. So that's my attitude, is they tried to kill him. So that means he refused to go along with their program. You see what I'm saying? Okay. And so 3 of his executives got killed. David Wilcock has a video where he talks about Howard Hughes. Originally, I thought Howard Hughes had been threatened, and that's why he was hiding out all the time. But David Wilcock has a video where he says that after World War II, Howard Hughes, everybody knows Howard Hughes is a big industrialist, and he was selling, had all these defense contracts. He built the Spruce Goose that's in Long Beach Harbor. I don't know if it's still, or I've heard they've moved it. But the bottom line, though, is that he all of a sudden, according to what David Wilcock said, Howard Hughes couldn't get any more defense contracts, and he got blackballed somehow. And so he got some ladies to go and sleep with the military-industrial complex types to find out from pillow talk what was going on. And that's when he found out that they were planning on, killing off, doing what the Georgia Guidestones talked about. They wanted the population down around 500 million, so they're going to use wars and other things to get rid of people. And so Howard Hughes had a set of manuals published, and for Kennedy, and Kennedy was implementing that stuff. Kennedy circulated $6 billion worth of U.S. Treasury notes. I've got some of them in my briefcase, and so what happened is they killed Kennedy. They killed his brother. They killed a bunch of people, and so I think that's why Howard Hughes is hiding out, and because he was afraid that he was going to be next. So I guess we'll see. Anyways, he's passed away now, so I guess it's not an issue anymore. So in reality, they're not after me. They're after you. I'm just in the way. Thank you, Donald Trump. I mean, he is doing what he is doing is absolutely priceless. He's a true American patriot, in my opinion. So appealable issues. Everything you do in a case should be with the objective of creating appealable issues. If you do a good job of it, you might even get the case dismissed before the show trial. Okay? It's just a big charade. Two enemies of the people are criminals and government. So let us tie the second down with the chains of the Constitution so the second will not become the legalized version of the first. Notice the government is the enemy. Okay? You have to understand that any court case is warfare. Okay, you are at war, and you have to treat it that way. You never ever tell the enemy what you're going to do. You break it off in their ass. You sandbag the bastards. It's warfare. It's flat out, knock down, drag out warfare. The greatest danger to American freedom is a government that ignores the Constitution, and I think we're there. Okay. In many cases, they just ignore the Constitution. It's Roman law. It's the Roman cult. They're busy trying to enslave you is what they're doing. All court cases are warfare. You are the enemy, and they are your enemy, okay? They are not your friends. You never tell the enemy what you have planned. You have to set them up and sandbag the bastards. Any violations of their procedures or denials of due process of law, you use that Constitution like it's meant to be used. And you start bringing up all of that stuff in there that they conveniently forget. Okay. This is the current so-called 13th Amendment. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. Yes.
Could you discuss in section 1 the difference between the words within the United States and in the United States? My understanding is within the United States, I accept that. That's geographically. In the United States has to do with the
District of Columbia?
Correct.
Could be.
So
I don't know. It's not something I've contemplated.
Just for the people who are listening, that I've found is I've noticed that all of the
when they use the different words are everything.
Right.
Okay,
So
words are absolutely everything.
So within is good. Within to me is representing the land.
Uh-huh.
In is not, and it's very clear. And every time I come across it, the lawyers always know when they write the codes, rules, regulations, public law, which is legitimate, things that are anyway.
Right.
Within is. I've always found it, and remember, you go and you're in this state.
Uh-huh.
It's not within this state. Some things say within the state.
Yeah, sure.
So if it's within, it's related to basically
the geographical area. Could be. I haven't really considered that. That's some food for thought, something to give some contemplation over. That's the first time you brought that up, actually, or maybe I just didn't remember
You
the
haven't
last.
heard it, but you're hearing it now, which is good. We
Well,
all
that's
hear
yeah.
things till we hear them.
That's right. Yep, absolutely. That's something to consider. Civilian is Roman law. Okay, you have to understand that. A civilian is, there's three definitions: a person not serving in the military, a lawyer practicing in a civil law jurisdiction, a scholar in civil or Roman law. Remember, there's a Black's Law Dictionary definition that says that Roman law, civil law, Roman civil law are convertible phrases and mean the same system of jurisprudence, which is municipal law. Okay, and the 1871 corporation is a municipal corporation. Yes.
I meant to look up the word civilian in Bouvier's prior to 1860 in their 1856 edition, just to see if there's a difference, because Black's, my understanding is their rules, their definitions, their legalese.
So what did Bouvier say?
I don't know. I haven't done it.
Okay. Okay, so there's two ways to conquer and enslave a nation. One is by sword and the other is by debt. Don't forget to subscribe to this channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. I'm just going to check YouTube here and see what I have. Oh, there's a few comments. Don't forget Lavoy. Don't forget the Ruby Ridge. Don't forget Waco, Texas. Don't forget the Wounded Knee Massacre. Or would you like some blankets with smallpox? Yeah, no joke. I agree 100%. We the people binding contract, giving the people in power to bind the government. We the people need to assert our rights. And words are everything. All right, so let's keep going here. That's the front page of my channel. The subscribe button's already clicked because otherwise it'll be red. The arrow's pointing at the bell. That's for notifications, and there's several selections. So I would suggest you click it if you want to be notified about new uploads. The corrupt Star Chamber courts of England required defendants to have counsel. Okay, so that's forced liar. Star Chamber stood for swiftness and arbitrary power. It was a limitation on the common law. Okay, that's evidence that you're not in a common law court. It's Roman law. Okay, in England, they had Roman law there, and we're going to talk more about that as it goes on here. But you have to understand that, matter of fact, I've got a whole presentation that we'll probably do tomorrow. What?
The camera.
Oh, it beeped.
Better take a short break.
Okay. Sure did. Okay.
So those cards use a lot of memory then when you're recording.
Well, I increased the resolution on the video, and I think that's part of it, right?
For sure.
Probably needed to make it less. Probably have to do that. That'll be something I'll do tonight or something.
Well, we're just changing like you're doing.
Well, but the files are huge too. What happens is the files are huge, and okay, so
Right, files are huge.
yeah, and I can't have files that big anyways. You know what I mean?
It's a lot of space to upload.
Yeah, yeah. SD card. Damn. What's up with that?
No, it doesn't recognize it.
Yeah. Maybe I have to try a different one, I guess.
Yeah, there's a HD one. They have different types.
I know. Yeah, it said I needed to have HD3. Well,
At
it didn't.
least.
It recommended it. Didn't make it mandatory.
Yeah.
But so I need to, and I can take up to 128 gigabytes. So I need to get some larger ones. These were all 64.
Right. They make them 128, I think, right?
Oh, they've got 256 at least.
Yeah.
Yeah.
Well, it can't take anything bigger than 128.
It's a shame. The dash cams that I have, they take the 256 gig. So they'll go for weeks and weeks before they start to recirculate.
Nice. I mean, yeah, that would be something if you would kindly send me your, consumer reports. Meaning you're the one.
Yeah. No, I've got a recommendation.
Yeah,
that's less
it's
than
just,
100.
and that's what I find in all of life. Everyone's like, okay, I don't want to do the work. That's we the people helping each other.
That's right. Yeah, for sure. So what's going on? Oh, there we go. It's rebooting. Weird.
Doing. That's what it started doing.
That was the other camera.
Oh no.
This is weird.
Replacement.
Oh, yeah, this is a brand new camera.
Why don't you tell her the truth?
Maybe, eh?
GPS wasn't
Yeah.
quite right either.
Ah, that's weird. So that had to do with that SD camera, so maybe I'll try a different one, I guess. And that SD card I put in there, it wasn't doing that before.
Well, there's a break in the action, Carl.
Yeah.
There's what my current investment
Oh,
is,
yeah.
and that exceedingly, and 70% would be $9,200 in 31 days.
Good.
And what they do,
I think we'll probably talk of that a little more in depth. I think maybe off camera, but
no, it's fine. And here's how these are the options, and then you hit my investments.
did the video
It was,
persuade some of your?
I went from, I started out at 80, I dropped to 50 over fear. And after listening to the 2 hour the other day town hall, I'm up to 99.5% positive.
Okay.
This is shows you a pie chart of what types of programs one chose, and then this is my first one maturing. I put in 5,000. They're paying back 4, and I have 16 days left. And basically, if you compound 70% over 3 months, you're at about 500%. He offers a 3-month commitment.
So what the heck?
Where it pays 800%.
Wow.
So I'm putting in 16 days. My plan is to reinvest the 10 for an $80,000 profit in 90 days.
Some reason.
He explains
This
how he
thing's
did
not
it in
getting
the
power.
2 hour. He got a lot. I got a lot clearer.
Yeah.
On why it's legitimate and how he can do what he does and his reasons for doing what he's offering to us as friends he hasn't met yet. It's my turn.
Mm-hmm.
And he explained his motivations and his history.
Let's try something else.
And there was a bunch of people from all over the world on the call. There was 275 people on the Zoom, and there's only 845 total. That's nothing. Like, it's literal. I mean, that's why when Glenn and Darren were talking about it, they were like, we have to wait and see if this is real, which was over the last 2 months or so when I was down there visiting. And they would whisper. You know, they wouldn't even tell anybody about it because they didn't want to be associated with something that wasn't honorable.
Yeah.
I mean, there's nothing for sure, but with his explanation, in fact, the reason I left a little while ago is they said I put another 250 in this morning, and already he got back and he wasn't supposed to be working today, but I guess he's at the office, so he sent me my email that my credit card charge had been approved, and he sent me the link that I have to then enter the card information. And immediately there was it showed up in my wallet, which I then invested for 70%, so $250 pays back $180 in 30 days.
That's a pretty damn good return.
Right. So and basically, you know how you have to try to find the right crypto he does all that. Because he makes his money from two sides of crypto traders, and he takes a cut. So he does that 20 times a day. And he gets his 2% of it like a broker. That's where, and then he can commit to two, like if somebody has some strange coin, and then, you know, so he needs the capital to be able to say, all right, I'll promise both sides. So if this guy fails, you still, sir, get what you're committing to.
Yeah.
So anyway, I'm excited about it. Like, it's like, wow. So anyway.
Yeah, the battery was dead.
No. So is the battery not the card?
Yeah, that's weird because it's plugged
Well,
in.
it might be. So let's see, I guess.
Unless the battery's no good.
Well, I got it charging now. So for some reason, it's not charging. It should charge but the charge indicator wasn't on. You know, this red light right here, there's a red light that shows that the battery's charging. And it wasn't on. And so that's what tipped me off to maybe the battery's got a problem. See the red light? This red light right there is for the battery.
So Scott, this morning after I
Do you need a proper
found out I had another
change the charger?
on a credit card, I sent
come
him a
with it?
request.
And that didn't, the cable came with it, but that's it.
The request, and I went ahead and entered my card information secondarily with an email that he sends. Once I sent that back, this said I had $250 available. And it said it right here. So then what I did
There we go.
was I went to
Card
Plan.
format.
plan, investment plan. What do I want to plan to do? Either do it now or later. These are the options. So I went to monthly here because, you know, I don't have 10 grand coagulated yet. So I hit invest now.
There we go.
Okay, so I then said pay via. Let's see, when it showed that in my.
So I need to make sure those batteries are charged. Probably ought to something to keep in mind
Now
anyway.
I have no.
Yeah.
My thing was empty.
Yeah.
Earlier
Okay.
I said I had 250 available, so I hit that.
Okay, thanks for bringing that to my attention. I think I need to make it a lower format because the files are too big. And that's what happened on that other one. Anyways, so we've already covered that one. It's a limitation on the common law. So it's a Roman law court. Although the right to self-representation is not a license to abuse the dignity of the court room, neither is it a license for the court to impose upon the defendant its own choice of counsel. The defendant's Sixth Amendment right to choose counsel or to proceed pro se is an essential part of his right to a fair trial. And in fact, that's what Ken, there's a Mark Stevens. Oh, it was you that was telling me about that. Are you going to give me a fair trial? I think that's brilliant.
Yeah.
So you can expose that they're not going to give you a fair trial. Anyways, it's all trust law. You got to understand that. So when they call the name, they're calling the name of a trust. And there's actually a guy that I met in Canada that told me that this is how he does it. And he talked about it, and he said he goes in there and they call the name, and he said, I'm a beneficiary of a trust with that name. And he says to the judge, he says, and I appoint you to be trustee, and I demand that you settle this matter immediately. Now, are you going to perform your fiduciary duty, or do I have to sue you for breach of trust? And the judge will get up, throw off his black robe, and walk out of the room, eh? And so, but the rumor is that after they come in without the black robe, and so they're different. It's a different kind of court now. And so you have to understand, I don't know what to do next. Okay, so I can't tell you what to do. So what I'm suggesting is you could point at the prosecutor and say, he's the trustee. You know what I mean? I'm a beneficiary. He's the trustee. And see what happens. You know, I'll bet you the shit will hit the fan.
Well, the judge could just be coming back in as a different judge without the black robes, but still be
Well,
because he's trying to be not the beneficiary, not the trustee either. It's the other one. Shit.
the prosecutor?
No, the judge himself. When you go in and you don't say that,
Right.
he's the executor. So he gets to decide on what's going on within the court.
Yeah.
He takes that position. But what you do, you turn it and you be the executor and beneficiary, and then you appoint him the trustee.
Well,
So
if you,
then
but
he has to perform the actions.
right. So, but anyways, I've heard that they come back in a different, and I don't know what to do. I've heard they actually can come back 2 or 3 times in different roles, and you have to know what that role is, and I have no idea what it is, you know, and that's why I don't. I basically make it so they don't want to talk to me, you know. In other words, I accuse the cops of attempted murder because I have a right to resist unlawful arrest with lethal force if necessary. And they want me to exercise my right so they can have an excuse to murder me like they did the guy in Utah. He had homemade plates on his car, you know. Anyways, it's interesting to see. I can see that having that common law passport will be useful. You know,
or a U.S.
Even-
United States of America passport because of the safe conduct.
I agree.
It's a felony, and I noticed in that code of Title 18 that defines the crime, it uses the word whoever, meaning the police officer is whoever. It doesn't say person.
Yeah,
That's
it's not
right.
persons anymore.
Doesn't
That's
say
right.
Person. It says whoever.
That's right.
That means it's the man, and you like to sue them in their private capacity, which is the correct.
Absolutely. Absolutely. I'm going to get a refill. There's nothing filling up my bladder anymore, so I got to get something to fill up my body.
It feels unnatural.
There you go.
And my understanding is that in today's world, it's not the minor estate. While it is, that's what they're using. It also said in the definition of the minor estate, it can be a decedent.
Yeah.
And a decedent is because we never claimed our securities at age 18 to 25, and under the shipping acts, under Title 46, they say that they say that the name entered the Navy as a merchant marine type thing at age 18, and then I went to sea, and at age 25, they said he never reported in because we didn't know to, and that's why I'm going locally to the county surrogate who's one of only 3 county lawful constitutional officers that the county that I live on must have 3
That's the equivalent to the probate court.
Yeah, and I will be doing that, and I'm just trying to get around to it like everything else we're talking about.
Well, I can make you around to it. You just round and it says to it on
I've heard that. I need a round to it.
it.
I need to get around to it.
There you go. I'm just going to reformat this.
And just, kind of, since there's a short break in the action, I will explain what happened to me when I was unlawfully taken into a superior or district court for the state during the course of my unlawful incarceration and unlawful trial. When I demanded trial by jury, I fired the public defender that was being forced upon me 5 different times in court. And I asked the judge why I fired him 5 times. Why is he still here? That public defender stated that his boss told him he could be there. So we know it's all crimes, and we're getting, we're planning on filing the criminal charges against the judge. But so, I never accepted. They wanted me to accept that representation. Now, according to what Glenn said earlier, there's the option to tell the public defender to do, with the contract, to do his job, or I'll file a bar grievance. But I was in jail and I had no option. I didn't know at the time what to do specifically, other than continue to deny jurisdiction. So the wrap up was they took the felony charges, and the judge, Superior Court / District Court judge, stated that she was unilaterally declaring a municipal court, and she would be the sole juror and trier of fact. She was giving me a jury trial. She would be the sole juror and trier of fact, and said I don't even have to show up for the trial.
But that's
How
a
convenient.
jury trial, not a trial by jury.
She knew.
That's called a kangaroo court.
I know.
Yeah.
We caught her in the kangaroo court, and Glenn and Charlie helped me continue to give enough evidence to build the record that we have a tremendous suit, and we're in the process of, after over a year, Glenn helped me file a quorum nobis months after the fact to try to resurrect the case, and he said if and when they ever respond, then that reopens the case. So after over a year,
They came back and said you didn't state any grounds.
they didn't state any grounds, and we think it may have something to do with Donald Trump and the fact
Could
that,
be.
and I had sent while I was in
Well,
jail,
that's why we need to get that thing refiled with some grounds.
I'm working on the flag jurisdiction situation because I want to,
The more you delay it, the more difficult it's going to be, I got to tell you.
well, they had, I don't know about that. They said 5 years, and she's the one at fault, not me, and so we'll see.
Well, you want to argue that stuff, you got to be prepared to argue it. So anyways, the plea.
We're back.
Tell them you want to a plea non-assumpsit, okay? And we're going to talk about that, why it's non-assumpsit. If they say that plea is not available, tell them under Article 6 of the amendment, you have a right to know the nature and cause of the accusation. If they try and force a plea, object to it 3 times, file a notice of objection to forced plea. Now, that's what that guy that was equity on the Tuesday meeting said, and that makes a lot of sense under equity. If you tell them I object 3 times, then but if you at any rate, you file and also I would file a notice of objection to forced plea, and he had some steps to do because they have to have 3 signatures to sell you into slavery. He talks about that. So again, you have to understand what's going on. Signatures. They always want you to sign things. When they give you anything to sign, just print on the line without prejudice. Okay. I don't sign it. I just print without prejudice is all I do. If you refuse to sign, they'll just put refuse there, and you signed it. I have signed bonds and plea bargains by putting without prejudice, and one time the judge sat there and watched me, and it was no problem. And so I think that's another reason why they don't want to talk to me.
Without prejudice, I can testify does work, because the last time they took me in for a fake warrant, when I was to county jail because I refused to accept the municipal court judge's authority.
Right.
So they took me to county, and I refused to accept the jurisdiction. And upon exit, I did write without prejudice, and I got another notice in the mail, a legal notice, all caps, legal notice from the municipal court telling me there's a $2,500 bail, not $1,500. And so far, they've left my body alone.
There you go.
Over.
Right.
So
You
without
just
prejudice.
keep putting without prejudice on there,
Without prejudice.
and they'll find someone else to mess with, because what it does is, if you read in the Uniform Commercial Code, it reserves your common law rights. Well, that's your right not to enter into a contract.
Right. And they can't force me into a contract.
That's right.
That's what they tried to coerce and intimidate in the free exercise of my
That's right.
rights. So
That's right. Yeah.
So without prejudice is
I think these days I would be considering, in fact I've done it, actually putting on no contract.
Yeah, you could do that, but without prejudice is what their code says. And so the code actually says, or any other something similar, which would be no contract.
Well, both in essence. So
Yeah.
no contract without prejudice.
Yeah.
So,
Yeah.
but I'd spell it out. This is no contract. I've got no contract with you.
Right.
You or your agency.
Right. So under Title 1, Section 1, a signature is a mark. In New Mexico, I put without prejudice on a speeding ticket, and the cop asked me, "Aren't you going to sign it?" And I told him under Title 1, Section 1, the signature is a mark. It can be anything. And for the purposes of this, it's my signature. And he took it, and it was no problem. Putting without prejudice reserves your common law rights, which means there's no contract. Call it a writ. Motions or begging. This is one thing that guy brought up about the equity, and I think that I think he's right. And I like the idea of a writ, because everything's a writ or a bill. Okay, a bill of you could call it a bill too, but a writ. I like a writ. It's even better. It's common law, and so you just call it a writ of. Matter of fact, I'll show you some of the ideas. I'm gonna start calling it a writ. Always keep in mind you're building a case for either appeal or a mandamus or a prohibition. A prohibition is a writ of prohibition, where you ask the Court of Appeals to to prohibit them from proceeding in their case because they've denied you due process of law. You see what I'm saying? And so when you file a writ, always bring in an order for the judge to sign. That's extremely important. And it is either that or plan to pay for a transcript, because the Court of Appeals work on records and evidence. Okay, you have to have a record or evidence or something to present to the Court of Appeals showing what you said is the truth. And so you always bring in an order, or plan on ordering the transcript. And if you order the transcripts, those things can be damn expensive. And the Court of Appeals works only on issues brought up in the lower court. You cannot bring up a new issue. You can only bring up issues in the lower court. And some issues, if you don't bring them up at the right time, too bad. You know, like the fake indictment. If you don't bring that up before the show trial, too late. You know, you got to bring that up in advance. Always confront the court and ask for a ruling for anything you file. Give the fake judge the order to sign. Make the order simple and easy for the judge to sign. If you put too much stuff in the order or anything controversial, the judge might not sign it, and now you have to pay for the transcript. And you defeated everything you're trying to do. Ken is a perfect example. He went and took in an order, and it said motion denied, and it says the judge is bought and paid for a clerk masquerading as a judge, and the judge looked at that and he says, "I can't sign that," and give it back to him. So now he's got to order a transcript. It defeated the whole thing. Why don't you just make it simple so that the judge can sign it and
He's giving us our freedom under their fake rules without him getting in trouble doing it.
well, some of the stuff you can put some stuff in there that say the truth, but that the judge is going to get in hot water. That's right. You want to make it nice and innocuous. It's like anything. So some of the writs that you could file is a writ of objection to the forced plea, a writ of demand for trial by jury is required by the Constitution, Article 3, and Article 6 an amendment, and Article 7 an amendment, a writ of objection to the Star Chamber, a writ of challenge to jurisdiction, a writ to suppress the evidence in the illegal search and seizure. These are all ideas that you can sign, that you can file. And so again, everything builds a case. And so then you take the writ, and here's some more ideas: a writ of objection to the testifying by the liars, a writ for nature and cause of accusation under Article 6 of the amendment. Excuse me. A writ of objection to the fake indictment, a writ to dismiss for failure to provide a speedy trial, a writ of objection to the satanic religious ceremony, a writ for demand for a fair trial, and I think that's brilliant. I think that's a great one to do. A writ of demand for the contract, a writ of demand to dismiss for lack of standing. And so it doesn't have to be complicated. This is an example. This is a really simple example. It's hereby ordered that the writ to demand to dismiss filed this day is granted or denied. It doesn't have to say anything else. That's all it has to say. And the judge signs it, and that's it. Now you got your evidence that you can take to the Court of Appeals. That's it. It doesn't have to be complicated. Trial by jury. So this always happens when you bring up the trial by jury. And even Ken has already, he did a motion, a demand for trial by jury, and the judge flat out told him you're not getting a trial by jury. And so he needed to substantiate that a little bit better and get an order for the judge to sign. Denied. You see what I'm saying?
Yeah.
And so then that's great. That's perfect.
Yeah, and your advice, Glenn, was ideal. I did that exact thing in a municipal case and wrote it on the back of a piece of paper I found at the court itself, or the municipal building, and the judge signed it, and I asked for him to also seal it with the court seal. He turned to the clerk. He said, "Do we have a court seal?"
There you go.
She said yes. So I have those.
Perfect.
Perfect. And and they didn't stamp it. I wanted a raised seal, which they did.
Yeah.
I didn't want a stamp. I guess
I don't think it matters.
It doesn't matter. Okay. But I wanted it actually raised, so
Right.
they can't say,
Well, that's common law, but now it's hard to copy if it's raised.
Right, but I have the original.
Yeah, I understand, but it's still hard to copy if it's raised. If it's black, you can make copies.
No, it came out fine.
Oh, did it?
Yep.
Okay.
It somehow reads the imprint.
Good.
But thank you, Glenn.
Okay. Well, so that's evidence.
It was a one pager, and I also, rather than give him a checkbox, I gave the bailiff, and I would read into the record what the two options were.
Right.
It was an order, and the order to demand trial by jury is hereby granted or hereby denied. I had two different pieces of paper.
Right.
The bailiff went up there, gave both to the judge. I had him do one at a time. There were 8 of them.
Wow.
Took over a half an hour to get through.
Good. So you give them great evidence, okay? So because they can, it's a kangaroo court. It's Roman law.
And by doing that, I do not have to order the transcript because I have the evidence.
That's right. That's
the
right.
key
Otherwise,
piece.
you pay transcripts get expensive.
And they also delay.
Right.
On purpose.
Right. Well, and they may, we can't find it, or the transcript can get modified or something. You get it signed in writing, then that's all that matters.
Yep.
A lot of times these, most of these courts, it's a recording, And so then somebody has to go into that recording and transcript, write down on the transcript, create a transcript. If it's a court reporter, then you got to have a court reporter in there to do the transcript. But a lot of these courts, there's no court reporter, and you have to. It is a recording, and so it's an audio recording. Somebody's got to create the transcript. So demand again. So this happens when you demand a trial by jury. This is what happens. This is what happened with Darren. When me and Darren went to, he had a trial. The jury was sitting in there in their box, and we went into a room with the judge and the prosecutor, and you demand for on the record a trial by jury and specify it's required under the Article 3 of the Constitution, as well as Article 6 an amendment and Article 7 an amendment. And the fake judge will say that he can only provide a jury trial under state law. And we had that happen. He only said, we can only give you a jury trial. State law only gives me a power to give you a jury trial. And we didn't catch this, okay? I told Darren that if he signed, they offered him a plea bargain, okay? And I said, if you sign it without prejudice, that means there's no contract. And so he signed it without prejudice. And ultimately, the thing went away because they knew they weren't going to get anywhere with him. But the bottom line, though, is that if we would have reminded the judge that under Article 6, Clause 2 says the federal Constitution is the supreme law of the land, notwithstanding any state constitutional law, and all judges shall be bound thereby, and have a copy of his oath, then what will happen is they'll have no choice but to find some reason to drop the matter. Okay, that's what will happen.
And the judge can't say that he only has limited powers under state law, because the Constitution is the supreme law of the land.
Yes, and he knows that. He's known that. They're trying to. They can and they do, and they sell people into slavery all the time.
They keep trying to sell. They're the ones who are the crooks, so that's why they continue to commit crimes. I mean, it doesn't matter whether it's one crime or 100. If they get you at the end of the day, then they win. Yeah, through their criminal act.
Right. And so and then the allocution. It's open on the record to the entire proceeding, and so object to the forced plea, object to the denials of due process of law. Object on the record to the entire proceeding, and so you know that actually there's stories of a lady, you know, like in California they have this 3 strikes and you're out thing, and so at the allocution is where you have anything to say. So you object to the proceeding, you object to the forced plea, you object to the denials of due process of law, and chances are what happened from what I heard. Okay, this is hearsay. With this lady in California is it was 10 years for bouncing a check, right? And so that's what she was facing. And so what happened is she said, I can't accept that. And the judge blinked, and he looked at the prosecutor and blinked again. And then he looked back at her, and then he said, well, will you take 5? And she figured out what happened, what was going on. And she says, no, I won't take 5. I want this case dismissed. So, anyways, my contact information is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page was deleted. I deleted it myself due to censorship on the part of Facebook. Quite frankly, I haven't been to Facebook in months, maybe years. My private group called Sovereignty International is being deleted. I need to go there. Matter of fact, somebody has offered to create a bot to delete everybody off of that group, because there's about 6 steps. And so I think I'm going to contact them and say, look, you know, how much do you want to create a bot and delete everybody off that group, and get them to do that. My pre-list private group is called Administering Your Public Servants. My Google private group is called Administering Your Public Servants. Follow me on Steemit at Sovereignty International. On HowTube it's called Sovereignty International. On Rumble it's called Sovereignty International. I deleted my X channel, my X profile, because of censorship on the part of X, but I do have one on Truth Social called Engineer Win.
Do you want to check YouTube? There's been a few comments.
Okay. Okay. 80% of these judges don't have a binding contract with their oath signed. That's a problem. Could be. I don't know. I usually get their oaths and have no trouble. Trafficking, selling human flesh, trading it in the stock market is still illegal. You got that right, and that's what they're doing. But you got to prove it and be able to enforce it, and that can be a little bit more difficult. They have to follow the Supreme Court rulings. The laws come from Congress. Yeah, you're right, but you're right. Congress isn't legitimate. See here.
Well, you have all three branches of government that aren't legitimate.
Yeah, right. Yeah, there's no separation of powers. My administrator told me that he's Article 3 in Article 1 court. I said Article 3 powers, not here. Administrator says it is. I said prove it. Put it into the record. None of them will put it on the record. Yeah. So anyways, okay. Well, that's good. Some good comments on YouTube. If anybody has any questions, put it in all block caps so that I can, and then I'll address it here. I'll check back periodically and address any questions that anybody wants to have answered.
What would it look like for them to prove jurisdiction in a perfect world?
Well, they can't. That's the problem.
So is that because of the martial law? Is that why?
They don't have jurisdiction. If you challenge jurisdiction, they don't have it. You have to agree. It's all by consent. If you're challenging,
in this country, it's
they
by
can't.
consent of the government.
That's right. That's right. They can't. That's the problem.
Right. And that was what Charlie, who passed away, his claim was he is the government and they don't have it because he doesn't want to agree.
That's right. Exactly.
When he got all the way back to the organic laws,
that's right.
That's where he said the whole Declaration of Independence was a war of volunteers.
Yeah. Right.
So he has to volunteer to everything: tax, loss of liberty,
right,
traveling, whatever it is.
Right. Yeah.
Well, I think one of the Supreme Court, Hale v. Hinkle, was mentioned specifically about the man's unlimited ability to contract.
Right.
To have unlimited contracts.
Right.
And that's what it is. Life is all about contract, and especially between each other and government agents and agencies. You contract, it can be just verbal. It doesn't have to be written. Just your agreement to do something or not do something is the contract.
Right.
And they get us all the time with that.
Right. And therefore, in the common law, that's why we do the trial by jury, because if you two men can't work it out, then either side has the option to call 12 other guys in.
Well, but see, it's administrative. If it's not trial by jury, then it's an administrative. There's no authority.
I understand that. Yes, I agree.
Well, the golden rules: do no harm, cause no loss or damage, and be honourable in your contracts.
So the appeal
mentions contracts right from common law.
Right.
So if they get you in a contract, they've got you under common law too.
Well, but is it a real contract? That's the question.
Yeah, I guess.
See, it's under the Uniform Commercial Code. It's easy for them to get you in a contract if you don't object. But again, in common law, it's completely different. And so they try and assault you with their commercial crap is what they do. And so I've always thought, I don't know if it's going to happen or not, but I've had a feeling I'm going to be in court someday, and I'm going to slap the bailiff, and I'm going to say, "Oh, I'm so sorry. I thought you wanted to do a commercial transaction." You know what I mean? And basically stand my ground on that. He's assaulting me with this commercial transaction, and oh, I'm so sorry. I thought you wanted to do a commercial transaction, and which is what they're doing. It's exactly what they're doing. And it was a federal court that I have a feeling that's what it's going to be. And I guess we'll see. I don't know how that's all going to play out or if it'll even happen. But that's what I feel like sometimes. I'll tell you right now. Anyways, a bill of attainder means a legislative act. Okay, a legislative act. No matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The Article 9, Section 9 is federal government, Section 10 is state government. Anyways, a bill of attainder, a bill of pains and penalties, is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is capital punishment. A bill of pains and penalties is something less severe. And that everything is bills of attainder and bill of pains and penalties.
So if a government agent is committing a bill of attainder upon us, because then that's treason, that's why it's capital punishment in a bill of attainder, because the punishment is capital.
That'll be for them.
Right. No, I know. That's the point. So when we call things a bill of attainder, it's because the government, man or woman, is taking action against us without authority.
Right.
And therefore it's a treasonous act.
Right.
Against one of we
perjury of oath.
Perjury of oath.
And at common law, there's no prisons. Okay, all prisons are commercial, and so that's why all prisons are commercial, and it's all the Vatican, and at common law, there's no prisons. It's literally an eye for an eye and a tooth for a tooth, or the death penalty.
I was watching a Western the other day, and they held a quick trial by jury, and the decision was 5 years hard labor for the widow who the guy killed, however he did it, because the woman now had nobody to do the work around the farm. So that was why there was no prisons. This is your sentence.
Your sentence. You got to go and work on the farm for 5 years. Yeah, right. Exactly. And so now he's basically her slave for 5 years. And so that's part of restitution. Right. You know, it's eye for an eye and a tooth for a tooth, or it's death. There's nothing else.
So the Vatican is.
So they don't have prisons at common law.
So the state has taken over the whole.
It's all Roman law. Yeah. It's all Roman law. Article 1, Section 9, Clause 3, no bill of attainder or ex post facto law shall be passed. Article 1, Section 10, Clause 1, no state. So that's the second one is the state. The first one is the federal. No state shall pass any bill of attainder. Okay, and so there's bills of attainder. The Texas Penal Code is a bill of attainder. And so then what happens? Think about it. If that judge, if you're in their kangaroo court, that judge is not a judge. He's an administrator working for him. We're going to go through that here in a minute. He's working for the legislative branch. That's who he's working for. And so if he does anything to you, then it's a bill of attainder or a bill of pains and penalties. If he tells you to do anything, that's a bill of attainder, bill of pains and penalties. If he tells you you have to pay something, that's a bill of pains and penalties. That order that he makes is a bill of pains and penalties. And so that's where it all comes to. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceedings. So these courts start off as a court of general jurisdiction. They're all Roman law, so none of them really operates as a court of general jurisdiction. As soon as you set foot in there, it's all about trust law. So that means inferior limited jurisdiction, inferior court of limited jurisdiction. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply.
So could tie all this in again, just back to the original purpose, which is creating appealable issues? The original.
Well, you have to understand the nature of the courts, right? And so that's all part of the appealable issues. You have to understand what's going on. It is familiar law that when a special statutory authority in derogation of common law, okay? So you gotta point out with your motions or your writs all of the defects, okay? And there's dozens of them. There's literally dozens of them. They do it every day, okay? So you point out all the defects and that they're not following the law. They're a bunch of thieves and pirates. You see what thieves and pirates, but you expose them to be such.
I just looked up the word writ in Bouvier's 1856. I think it's worth pulling up on the screen on your 1215.org. You go to your website, your ability to go online, 1215.org. It'll take you to
Okay.
you have Bouvier's there? Law? Is there
Nope.
Search this website.
yeah. No, I just put in my search. Yeah, try search this website. The yellow. My request took me right to
Writ?
Writ Bouvier's 1856.
It's not finding that.
Letter W. Well,
Sorry?
if you go back to Google and ask it, I'll tell you what I put in, and then it came up without going here. So, the Bouvier's Law Dictionary online. Let's see what happens. There you go. Now go to. I went to text W. Yep. W. There you go. Now go down to writ. I think it really.
See, the thing I don't like about this is you don't get page numbers.
Right. We can just go for today's purposes, just to be able to WRIT. This is like the last, for me, the last dictionary that talked about common law jurisdiction. Okay, you're close. Go up a little. Red. It talks about a sovereign, which is me.
Right. A mandatory precept issued by the authority and in the name of the sovereign or the state for the purpose of compelling the defendant to do something therein mentioned.
Right. So that's
It is
why-
issued by a court either or other competent jurisdiction. It is returnable to the same. It is to be under seal and tested by the proper officer and is directed to the sheriff or other officer lawfully authorized to execute the same. Writs are divided into original writs of mesne process of execution. That's 3.
Right. So my
There are
plan-
several different kinds of writs, some of which are mentioned below.
Right. So my plan now, after listening, and I'm a sovereign, I'm a state, and I'm going to sign myself and seal the next time. Like I'm going to actually sign my writ as a sovereign when I'm in that court, ordering the court to do something. That's where I'm at as of right now.
Look at this, writ of deceit. The name of a writ which lies where one man has done anything in the name of another by which the latter is damnified and deceived.
Oh, it's huge.
Yeah, no shit, eh?
It's I can't wait to spend another.
Yeah, no shit.
12
That's some
hours
good stuff
signing a
there.
writ. It's like, but just for That's why I thought it was worth.
Yeah, no shit. There's some
Go
good
back-
stuff there.
Go back to, look, you didn't mention the word practice, right? I'm practicing law as a sovereign or a state with a small s, and it's a mandatory precept issued by the authority. That's me. I'm issuing a writ. I'm not asking the court. I'm ordering the court.
Name of the sovereign or the state.
That's I'm going to put the name of I'm the sovereign and I'm the state. The state of me is, and I'm going to seal it because it said here, it's issued by a court. Remember, I mentioned that back when, not today, but the court of France, the court of Spain, there's the court of Nelson. That's my court. Every man is a court. And under common law, I have the rights of the sovereign.
Yeah. Yeah, it'd be interesting to read through some of these. Writ of detenue.
I guess the only way they could get around that is if there's a sovereign already in place, which would be the monarch normally in other countries.
Right, that's why they all need lawyers, and that's the beauty of what Charlie claimed before he died. Where he was heading was this practice where he would go in, and the moment the other party has an attorney, Charlie, as the sovereign, becomes the highest authority, and therefore he now turns the judge into a administrator for him. And that judge has to do whatever the highest law in that court is, and it can't be the attorney for that other man or woman, because they, by virtue of bringing in an attorney, have now surrendered. And that's where he was headed. So using this writ, I'm going to go, this is exciting, because the writ now changes my actions, like not motion, but a writ as a sovereign. Not a writ asking the court to please sign my writ, agree to my writ. No, I'm ordering you. It is written.
Well, you're changing the competent authority in the court.
Exactly.
Of the court.
I'm the competent authority. So thank you for allowing me to interrupt, but I thought it was.
Yeah, there's some really good stuff in here. It's something that is going to take some further study for
Right.
sure.
The key is the key is going to 1856 Bouvier's. And then, of course, I know you.
I'm sure you can find the same kind of stuff in any other good law dictionary.
Well, the question I would have is I have found that
In the old ones, especially,
right, no, Black's law today
doesn't tell you all that stuff.
Transferred the legalese to their way of winning.
Right, of course.
And so I can't use Black.
Black's fourth is probably the
Oldest.
oldest
that's the
decent
closest.
one.
Okay.
Yeah. You can. I've got copies of the older ones, but they're not that good. And I've got copies of the newer ones too, and they're definitely no good. Because, like you say, they've transferred everything into pure legalese at that point.
Yeah. To tilt the outcome in their favor, which I understand. They're entitled to be crooks. It's a free country. But the minute you violate my freedom, now you have to lose your liberty. And the problem is that in my mind, until I go to the county surrogate or probate court, and see, my understanding quickly while Glenn's out of the room, I'll just mention that my understanding of where I'm heading is, meaning he's indisposed, is if I was a man going on a ship to leaving the port at age 18, I was supposed to put my will on the record with the local surrogate or probate court. In case something happened to me and I never returned, my will was on the record. Then they could do what I wanted. And if they wanted to declare me legally dead, then here's his will. The problem is we don't do that at age 18. And
Yeah, but we're not going on ships either.
I understand that, but so I'm talking about how they my name was put on a ship And that's how they're making me a decedent and attacking me falsely. All true, but I'm just trying to cure the problem. I'm not trying to argue with them. It's like, how do I cure it today? And the woman made some sense. She's a friend. Blessing was her name. Her action was she probated her will on the record as I'm back. I'm on the land. I'm in the probate court. She opened up a probate. She probated her will that she, quote, forgot to file before she got sent on a ship. I mean, it's all games they play. I'm not saying it's right.
Right.
I'm not trying to argue the
But they kicked her out of jail because of that.
Yep. And now she's had, to my knowledge, no issues. And I can't wait to, and just as a reminder, if you go on the New Jersey, look up constitutional officers of a county, there's only 3 officers in the county, the original county, the land county, not the county they created on paper. There's only 3 officers that are constitutionally bound to me as a man. The sheriff, the county clerk, and the surrogate. That's it.
Which is the probate court.
Right. And I think it's all about your satanic.
It's interesting they changed the name to surrogate.
It's always been surrogate here.
Oh, has it?
That's original. Yeah. That has its roots in probably English common law, if I'm not mistaken.
Could be, but what about the like the coroner? Because that goes back to English common law too.
I can't answer that. All I know, I guess if you're dead, then you're really dead. And the coroner
And it don't matter.
Exactly. Right. We have the body. There's the right.
The coroner's officer in England was the cop. Because while I was serving over there, when I went to sudden deaths, I was there as the agent of the coroner's office.
And that's why today, when someone passes away, the cop shows up and can't leave until the coroner gets there. Once someone's dead, the executive office, the cop will show up, and there's always someone posted with that dead body till the coroner shows up and legally declares them dead.
Wow.
They're not dead until the
coroner decides.
Exactly.
Actually, no, it's MD can come out as long as it's a doctor.
Well, I don't know. Maybe, but maybe
Because then coroner
right,
shows
they
up
have a
after
license, right? Okay.
But they're licensed. They're licensed to decide on death.
Oh, right. So basically, somebody under the authority of the coroner comes out.
I guess they would be sub authority of the coroner as well in deciding death.
Right, which is under the attorney general, and so okay. So anyway, that's all I felt helpful to, help some of your listeners of clarifying what's.
Okay, so it's familiar law that when a special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. So that's a bill of attainder again. To be the statutes which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. Okay, that's an old court case. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to a mandate of legal authority and without regard to his own judgment or opinion concerning such act's propriety or impropriety. Such a given state of facts exists when such a state of given state of facts exists. Discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. When acting to enforce a statute and its subsequent amendments to the present day, the judge of municipal court is acting as an administrative officer. It's a bill of attainder. And not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity.
That's interesting because, again, going back to my days as a cop, I had discretionary power when on duty.
Right.
So I try and notice the difference between cops over here and in other countries. And
Well, they're probably the same.
No, because they don't seem to have discretionary
Here.
here.
Is that right?
Yeah, under common law, American common law.
Right. That's
They
interesting.
don't. If they've stopped you, that's it. The chances are you're gonna get something.
Right.
The only way it doesn't happen is if you can get out of it by pleading that you know, in some way you haven't committed the crime.
Right.
In which case there's nothing for them to proceed on. But otherwise, you know, you're going to get a ticket, you're going to get arrested or whatever. There's no discretion about it. It's like shoplifters. We have the discretion to be able to discuss with the owners of the store whether, you know, the person was going to be arrested. If they were previously of good character and it was just a one-off thing. There was no
So if the
previous
store
record.
owner doesn't want them arrested, then you want to arrest them?
Yeah, because they have to complain. There has to be
Oh,
an
right.
injured party.
Right.
So you have to take the, you know, the statement of complaint from them.
Right.
So if they turn around and say, no, we don't want to complain, but then they're banned from the store and clear them out, never want them to be here again,
Right.
then that's what you do. But there are times, I mean, there's times when I've kind of pled for a case, usually in food. It's usually when people are stealing food.
Right.
Because that to me is just, that's ungodly, you know. I mean, if
Really?
if you're complaining,
They
you're
want to eat.
asking people to be arrested
Yeah.
because
They want to
hungry.
eat.
That
Yeah.
just frustrated the hell out of me.
Yeah.
So I
No
would
shit.
always plead the case for them, you know,
Right.
unless they were just abject crooks and
Right.
you did a check on them and you know you got a record. Long
Yeah.
as they're on.
Yeah.
No, you're just a crook. You're just a thief. I don't care whether it's for food or not. So you're
Right.
gonna get arrested if they want, and off you go. But there's times when I've gone in and I've had valid cause to say to the owners, "Well, this person just generally and genuinely just wants to eat."
Yeah. Right.
And that's the reason they stole it. And more often than not, they've paid for something
Right.
but stolen other stuff.
Right.
You know, you can argue the point if they've just come in and just stole but not bought something and stolen,
Right.
then you know you could.
That's one thing. Yeah.
Yeah, that is a different mindset to me.
Right.
So I pled that case, but again, many of the owners they won't. Some did. Some just said no. Okay, I agree with you. I'm happy to never let them back in the store again.
Right.
But if they do, then you'll be charged for other trespassing offences and things
Right.
like that. So yeah, just thought I'd bring that up. So,
Right. That's interesting. I know. I look at the Magna Carta and it says, "No bailiff shall put his law to you without producing witnesses and evidence." And I mean, that's an administrative proceeding. That's a bailiff or a police officer or a government official, basically, like what the cops do on the side of the road. They're putting their law to you. You see what I'm saying?
yeah.
And they can't do that without having witnesses in England, at least. And none of that stuff is incorporated into our stuff here, and so you can't bring that up. The only thing you can bring up really is common law, which is talked about in the Magna Carta. You know that chapter 29 of the Magna Carta talks about the common law and the law of the land. You can't go upon them except a jury that appears with the law of the land. And so the court cases talk about that, but you can't really bring up. You know, I brought up stuff like to none will they sell justice. You know, well, I do that here all the time. Anyways, I just rail on them for it. They selling their just us. So check out my other videos: the Bankster Thieves playlist, Roman Cult playlist, bankrupt corporate so-called governments, bar members 1 through 9, do-it-yourself how not to volunteer for the selective service in the draft, martial laws here, do-it-yourself no income tax, do-it-yourself free mail, do-it-yourself kangaroo courts. This is actually number 32, so we'll change that to 32. Canada Border Pigs playlist, bar members and their satanic connections playlist. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for the agency. Judges have become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Oh, look at that. Some clerks operating under Roman law. Judge works for the state, prosecutor works for the state, police or witness works for the state, and those are all military uniforms. The prosecutor's got a military uniform on, and so is the judge. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. The word administrative is synonymous with the word executive. The word administrative connotes or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies, right? So administrative is legislative. That brings it to the bill of attainder. And purposes already declared by the legislative body. In fact, it is common to use the two terms in tandem.
That's confusing when you've got the legislation and administration,
Right,
and an administration that's an executive.
right. Yeah, I know, that is. Well, that's why I say there's really no separation of powers. And so that's really what it comes down to. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there's no jurisdiction, there's no judge. The proceeding is as nothing, such as one in law from the days of Marshal Saya. But in fact, in law, such statutes are intended to apply to those who are here as residents in the state under the Interstate Commerce Clause of the Federal Constitution and the so-called 14th Amendment. That's a summary of what that case says, and that's why it's not in quotation marks. Justice Thomas concurring, J. Mascott, constitutionally conforming agency, adjudication. Cases involving deprivation or transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts. And that's April 14th, 2023. That's a year ago. Where controversies of such a character as to require the exercise of judicial power defined by Article 3, jurisdiction thereof can only be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer or administrative or executive board, since they're incapable of receiving it. And there's lots of court cases. That's Williams versus United States, 1933. So this is nothing new. Sibak versus Wilson, judicial function cannot be delegated to non-judicial entities. Freytag versus Commissioner, non-Article 3 courts must operate under judicial supervision. U.S. versus Raddatz, Article 3 courts must resolve core constitutional disputes. United States versus Lee asserted that judicial authority is required for disputes involving private rights. Martin versus Hunter's lessee, judicial power cannot be delegated to non-Article 3 courts. See, in the federal courts, they have a magistrate judge, okay? And the magistrate judge is I call him a fake wannabe judge. Matter of fact, I've actually told them that. And they don't like it, but it's the truth. They're not Article 3 judges. And so that's why they have to have an Article 3 judge there. The magistrate judge makes a recommendation, and then the Article 3 judge either accepts it or makes another ruling.
They're usually just lawyers who have been given authority to act as a magistrate,
right,
in a lower court.
Right.
That's all they are.
Hayburn's case, non-judicial officers cannot perform judicial functions constitutionally reserved for Article 3 courts. Thomas versus Union Carbide Agricultural Products emphasized that Article 3 courts must adjudicate core issues. Kroll versus Benson, non-judicial agencies cannot resolve core legal issues. Plout versus Spendthrift Farms, finality of judicial decisions can only rest on Article 3 courts. Lynch versus Household Finance Corporation, private property rights are subject to judicial review under Article 3. U.S. versus Lee, the exercise of judicial power is necessary to determine property rights. Loretto versus Teleprompter, Manhattan, The permanent physical occupation of property by the government constitutes a taking requiring just compensation. Missouri versus Jenkins, judicial control of government actions involving private rights. Wilkie versus Robbins, judicial redress available for unlawful government actions involving property. So a little bit about history. Why is this the case? So in 1861, the southern states walked out of Congress. That's really a big problem. Congress failed to have a quorum. Congress couldn't conduct any business. On the 15th of April, 1861, under executive authority, Lincoln, a bar member, ordered Congress to reconvene at 12 Stat 1258. That was actually Executive Order number 1. 1871, Congress created a municipal corporation at 16 Stat 419. And this is Black's Law Dictionary, 4th edition. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. And that's Black's Law Dictionary, 4th edition. Governments descend to the level of mere private corporations and take on the characteristics of a mere private citizen where private corporate commercial paper and securities is concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. So that means that Congress is maintaining the corporation, the 1871 corporation. And someone brought up that 1871 corporation had been dissolved, and that's not true. What they did is in 1873, they passed an act that changed it dramatically. There was originally a governor and there was an executive, and there was a bunch of people appointed, a member for the House. And in 1873, they went and canceled all of that and put 3 commissioners in place. And I think that the 3 commissioners now are like Nancy Pelosi. I think Congress is the 3 commissioners that are, but I don't know. I just know that there's 3 commissioners. I think the Speaker of the House is one of them. She's responsible, or he, whoever it is responsible. Member Pelosi was the one that the Capitol Police, Trump offered to, if you watch Kash Patel's video about government gangsters, he says that Trump offered to bring in the National Guard to provide extra security for the election and the everything that went on January 6th. And Pelosi turned it down. And so that means that Pelosi is one of the commissioners. You see what I'm saying? Anyways, the 1871 corporation is operating under the Commerce Clause. The Supreme Court ruled on a case that Lincoln failed to like. I think it was Ex parte Milligan, but I'm not sure. Military tribunals cannot try civilians when civil courts are available. Lincoln sent troops to the Supreme Court, which resulted in Rule 45, which does exist to this day. Rule 45 says all process of this court issues in the name of the President of the United States. So think about it. That means that the Supreme Court, there's no separation of powers. It's all a big charade. And so
I have to question some of the quotes, I guess, from previous court citations in some of the other graphics earlier on. The older ones I can understand because some of them were actually pre-1871. But, I mean, the ones that were in the 40s and the 50s of last century, the 19th, 20th century,
right,
so, they're still ruling on the Article 3 courts.
Right.
It must be adjudicated, blah, blah, but
right.
they haven't existed for 150 years. So
well,
why are they still ruling?
I think that and it's still, they have to maintain the illusion. Okay, they want you to think that there's, and so when push comes to shove, though, the executive can say no. Okay, and this is one of the things that I bring up in my Roman law one. I think it's in the Roman law. And one of the other presentations I have, the clerks, 107 actually talks about how the clerks in the Supreme Court heard Roberts screaming at the top of his lungs, "We cannot accept this case." And they think it's the Brunson case, okay, because it's political. And so I have another presentation about political. It's political, okay? And so the Supreme Court doesn't want to get mixed up in political issues. If it's political, there's even court cases that talk about it, and it's an old court case. It says that the executive, or the judicial branch has to follow the executive branch. And so now they're saying right there, there's no separation of powers. The judicial branch is just another branch, and they're doing what the executive tells them to do. You see what I'm saying? And that goes back to this Rule 45 of the Supreme Court. So at the end of the day, if it's political, they don't talk about it. They just ignore it. They pretend it doesn't exist. You see what I'm saying?
It's the president that nominates the Supreme Court justices anyway.
Right.
As well.
Right.
So how can that be a separation of power right there when the
Well,
executive branch is the
Well,
one
they have
that's,
to be approved by the Senate.
They have to be approved, and then also
I guess,
that they cannot be removed. Once they're in there, they cannot be removed. The Senate has to remove them. It's not that they can't be removed, but the Senate, and it's there's actually a video that I played, I think it was last weekend, where since the 1808 was when the Judiciary Committee was created in the Congress, and there's been like over the hundreds of judges that have been appointed since the Constitution was written. There's been like 18 of them that were investigated by the Judiciary Committee on the Judiciary, and of those, like 8 of them resigned, and then the other ones were removed, or 8 of them were removed, and then other ones resigned. I can't remember, but it wasn't that many, you know. So it's an act of Congress, literally, to get a judge removed, and so they don't normally do it, you know.
And Obama, during one of his shenanigans, they were planning on trying to do a recess appointment to the Supreme Court or something. And so the point is the Senate was originally set up. And I don't think they were willing to jump that fence yet.
Yeah.
To show the world how fraudulent we are. Like they're like, all right, we better not do that.
Right.
A recess appointment. So.
Yeah, there's going to be huge changes. There's another video I want to play tomorrow that talks about upcoming events. That's another 107 video, and it talks about upcoming events. There's going to be huge things. Some of it was alluded to in that 107 video today. There's going to be more tomorrow. That'll it's just huge. The stuff that's going down. Trump is really working for the people, in my opinion. And I can't imagine how anybody could see anything else, but you never know, I suppose. Let's see what the chat is doing.
Still have a lot of people working in the administration, in quotes, that are probably none too happy about returning power back to the people.
Oh, I'm sure there's all sorts of bureaucrats that are really, really upset about it, but there's nothing they can do. There's a bunch of them that got fired.
Yeah.
And so there's from what I'm hearing, there's a thing that was set up by Carter called the Senior Executive Service, and that is really the real deep state. And they're basically appointments. They're not they're appointments. They're not political appointments. They're appointments, and once they're appointed, it's for life. And those are the ones that are really they're kind of like oversee all these agencies. And they're the ones that are really causing all the problems. And so, anyways, that's the rumor. So, anyways, United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3. Of making all needful rules and regulations respecting the territory belonging to the United States. So, and I told the judges that in my federal court case, you're not in Article 3 court, and so they can't rule. Basically, it has to go to an Article 3 court, and I actually had a common law ruling that I filed into the case, and I said this is the only Article 3 court that's ruled in this matter, and you have nothing to say about it, and so it's res judicata. Anyways, Congress passed the Code of Law for the District of Columbia, 31 Stat 1189, March 3rd, 1901, which is now known as United States Code, and all courts, federal, state, all operate under United States Code. There's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Derogation of common law means an inferior court of limited jurisdiction. Under Texas law, no act or omission is a crime unless made so by statute, which means there's no common law offenses. The legislature may create an offense and in the same enactment provide exceptions to its application. Derogation of common law means it's an inferior court of limited jurisdiction. Assumpsit, quasi-contracts. Remember I talked about pleading non-assumpsit. And this is all commercial. This is all talking about the minor estate. In its origin, an action of tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first only upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt. So these are commercial words now. The superseded debt became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, competed with equity in the case of essentially equitable quasi-contracts. Growing out of the principle of unjust enrichment, surely it would be hard to find a better illustration of the flexibility and power of self-development of the common law. Black's Law Dictionary, 8th edition. So this is all coming from England, and it's all Roman law. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. So it's going back to Roman law. So this is all Roman law. And so we'll be talking about this. I've got another presentation about Roman law, and it's political. And so we're going to be talking about this, maybe later today or maybe tomorrow, depending on how far we get on this one. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law, which means the minor estate. A penal action is an action on a penal statute, as in Texas Penal Code. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Penal and bill of pains and penalties. Okay, so these words are not there by accident. Where an action is founded entirely upon a statute, and the only object of it is to recover a penalty or a forfeiture, such action is a penal action, right? Bill of pains and penalties, recover a penalty, such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, okay? Pecuniary. So you have to understand the pecuniary is going to come up too, okay? So pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous. So it's a bill of pains and penalties. So it's unconstitutional. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit. If you nail them down and about the nature and cause of the accusation, if you nail them down, they will come out and tell you it's quasi-criminal, which means it's assumption. That's why you plead non-assumption. I don't agree. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. The actions are civil actions, on the one hand, closely related to criminal prosecutions, on the other hand, for private injuries in which the party aggrieved may, by statute, recover punitive damages. Pecuniary cause, such as arise either from withholding ecclesiastical dues or doing or neglecting some act related to the church, whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtraction or withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy as pensions, mortuaries, compositions, and the like. And that's Holthouse, A New Law Dictionary, 1850 edition, but they're quoting Book 3 on Blackstone's Commentaries on the Laws of England. Pecuniary. So it's all here. This is all Roman law. And it's the Vatican, and it's unconstitutional because the First Amendment says Congress shall make no law respecting an establishment of religion. The United States shall guarantee to every state in this union or republican form of government, Article 4, Section 4, as one of we the people, the defendant is a state in this union because we the people are the state. This is a state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. Yes.
Why does the 11th Amendment not negate this case? Because the 11th Amendment was passed in response to Chisholm versus Georgia.
That's interesting. I have to look at what the 11th Amendment exactly says. You got to look at the wording.
And also the style. The words judicial power are in the same order, but they switch the style
Right.
of the original Constitution. So why?
Right.
Like, what was the impact? What were they trying to accomplish?
Well, we can.
Were they trying to give the District of Columbia more power? What was going on? Why was the 11th Amendment passed so quickly? Once Chisholm versus Georgia made Georgia responsible.
Well, let's go and look at what the 11th Amendment says. Now, your best Constitution only has the Constitution. It doesn't have the amendments.
That's true, but the reason for the amendments, in my opinion, the reason why the state said we're only going to agree to ratify this if you add some bills of rights.
Yeah, but that's not my point. My point is where am I going to find the original style? I got to go, and if I pull up a Constitution, it's not going to be your best. And so where do I find it?
Just go to archives.gov and they'll give you the proper style of the 11th Amendment. Meaning on Google or whatever.
Yeah.
And did you notice that when they're preaching they put the numbers in brackets? It's the 16th. Like, they're telling the truth all over the place. It's just we don't know what it means.
Okay, so search what now? Go to archives.gov?
Bill of Rights, and then that should be enough. And if it isn't, you can always just find the archives.gov. National Archives, you're close. No, okay, there you go. A transcription. No, down. There you go. I always found that to be legit. Mhm.
Doesn't have the 11th Amendment.
You click on 11th Amendment to 17. Go down.
Right there?
Yeah, see what that. Well, no. That was just. Down a bit below the 10th. There you go. Try that. There you go. Try that.
Same thing.
So it doesn't have. So some would say, here's my argument, my position right now. Why does Chisholm versus Georgia still matter to
Amendment 11.
Is because the 11th Amendment was passed after this Constitution for the United States of America, and I claim that the 10 amendments are only needed when I'm on federal territory, which the territories, Ohio, the Northwest Ordinance, like the founders knew that free citizens were going to be heading out to the Ohio territory, and Congress was going to be in charge until a free state was formed, and that's why they had to have the Bill of Rights, because they knew that the governor and his commissioners from Congress, when they were on the territories before they became original free states, we needed something to say. Congress can't just make up anything and say it applies. And therefore, the Bill of Rights was.
Yeah, well, I thought the Bill of Rights was just a confirmation of what was written in the.
That's what we're told. That's what we're told in school. I'm telling you what I think. Why they had to do it, because they knew that this monster they were creating was going to. They were given all that land.
Yeah, that's a lot.
See, there's nothing here that's from the National Archives.
Well, then maybe that's why the 11th Amendment, which tells me Chisholm versus Georgia, if I sue under the original Constitution, when it says the United States shall be a party, that's why they're in so much trouble if we come in as a man to this day. So what the Congress was trying to do was to throw some smoke in our eyes and pass the 11th Amendment to try to tell everybody, no, the original state's not really responsible, because at the end of the day, Georgia had to buck up and pay Chisholm.
So the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against any one of the United States by citizens of another state or by citizens or subjects of any foreign state.
And I don't know for sure that the words suit, law, and equity are properly, but I do.
Well, I mean, until you can come up with something that's going to be verifiable, then this is all we got.
Okay. Well, I will look, and we can come back to it when I find it. I'll do my research while you're continuing. If I find something worthwhile, we can revisit it.
Okay. So, anyways, moving on.
But I'm going to quote Chisholm versus Georgia as my authority.
Of course, I would.
Right. But I'm telling you what they're going to claim, why it. So they're going to explain why the 11th Amendment changed the judicial power.
Actually, I'm a state, and so it goes back to that common law court case in Dallas, where he said he was a state, and we the people are the state.
That was great. I mean, if anyone in the chat is interested in reading, that would be something to send them if they request it.
Yeah. Okay, so we're going to keep moving. A Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by session of particular states in the acceptance of Congress become the seat of government of the United States. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And that's Article 6, Clause 2. And so that's gold right there, I'll tell you. That says a whole bunch. Supreme law of the land is an interchangeable phrase with common law. The courts have ruled that. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power nationally, covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So that's saying a couple things. First of all, it's saying that cases between U.S. citizens and state citizens don't get Article 3. And it says that in the District of Columbia, it's a dictatorship. And so we're going to talk about that further right here. Plenary power. Remember, I talked about plenary power nationally. Plenary is total. It's dictatorship. Plenary jurisdictions, the court's full and absolute power over the subject matter and the parties in the case. Plenary is full, complete, entire. Plenary is full, complete in the courts of admiralty and the English ecclesiastical courts. Okay, so this goes back to the ecclesiastical courts again. Okay, so if you're in the District of Columbia, it's the Vatican. Cases or suits in respect, that's Roman law. Cases or suits in respect of the different course of proceedings in each are termed plenary or summary. Plenary are full and formal suits. Those are the proceedings must be full and formal. Bouvier's Law Dictionary. Plenary. A plenary power or plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power is complete power over a particular area with no limitations. It's Roman law. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. So regulations, if you're subject to the regulations, you're property of the government. Every corporation, for all its purposes, is an agent of the bitch, or the son of a bitch, as the case may be. And that's the Government Corporation Operation Act of Canada. And then the Canadian Ownership and Control Determination Act, Section 2. In this act, owned means subject to the regulations, which means if you're subject to the regulations, you're owned, you're a slave. And the same thing applies in the U.S. Constitution, Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of the property belonging to the United States. A U.S. citizen is other property belonging to the United States. All subjects over which the sovereign power of a state extends are objects of taxation, but those over which it does not extend are, upon the soundest principles, exempt from taxation. This proposition may almost be pronounced self-evident. It's obvious. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which exist, which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. Nor does the conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both. The sovereignty, that's Luther versus Borden, 1849, right? That's the same case that that talks about the judicial branch needs to follow the executive branch. So that's before the Civil War. The sovereignty of the United States resides in the people. Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. So this is all going to the minor estate. Individual means a natural person. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. That's the Code of Federal Regulations, which means it's for property of the government. Court means a court of law with jurisdiction over the parties and the subject matter. It's got to have the subject matter. Entity means any owner of a Treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And so that's all Roman law. So it's the minor estate. It was brought into America with the Code of Law for the District of Columbia. The legal estate to be the Sestique Jus at 31 Stat 1432, and use is short for usufruct under Roman law. It all goes to Roman law. When a state forms a constitution, this is Luther versus Borden again, remember? 1849. When a state forms a constitution which is approved by Congress, it's a stop to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the political department. So again, that's 1849. That's before the Civil War, too. The judicial is bound to follow the political department. So in some respects, there's no separation of powers. Yes.
It says approved by Congress.
Right.
The original colonies formed their constitutions, and they were all good. And then over time, each one started to put in
right
a new one, which then had to go to Congress, correct?
A new state, yes.
How about an old state, an original state that
changed their constitution? I don't think that has to go to Congress.
Okay.
I think it's only once. Once Congress approves it, then I don't think it has to go to Congress again. I don't know. Might.
Yeah, there's been 3 in New Jersey. What year was that case? I'm sorry.
1849.
Right. So New Jersey came up with their second one in 1844. So I don't know that had to go to Congress. And it's basically whatever's in the Constitution of the state. If it's not under, if it violates Article 6, Clause 2, then it does. It violates it at that point. But under the war acts that were going on, everybody had to get an approval, especially the 10 states that were in the Confederacy. They had to get their constitutions approved by Congress.
That's true, yeah, they did.
So this was talked about approved by Congress. Those were probably states coming into the Union under the original Northwest Ordinance.
Yeah, I'm not sure. Matter of fact, there's some question as to whether, like Arizona, that's like 1907, New Mexico, whether they're actually territories.
And I absolutely think they are, which goes to why the Bill of Rights 1 through 10. I'm still okay if they come against me. I could, if I had to, use that, because you quote Amendment 5 and 6 all the time for
right
seizure.
Right.
And I'm claiming the reason why the Founding Fathers said we need these is because they recognized that this district was going to eventually have so much authority and power and would use it against the free people. And they had to say,
Well, I think that's why Congress went and did that Northwest Ordinance too, because they knew that shit was
exactly.
going to happen.
Section 14. Now, how does that go with appealable issues? I mean, you haven't brought up any of the organic laws.
No, I haven't. No.
Which is so critical as well, correct?
I agree.
So go
I
back
agree.
and watch your video. Which one is it?
Yeah, there's a bunch of them. There's
Organic law?
about the organic law, huh?
You have one termed organic laws?
I've got
Yeah.
several of them.
Okay.
Declaration of Independence, where we're talking about that. There's all those videos we made in Texas when we
I
were
don't
there.
know where they are on your website. I don't know if you
There,
posted
I don't have them actually on my website. I probably could make a separate heading.
I think
That might not be a bad
I'll
idea.
put- Guess what?
Yeah. But if you go to my channel, there's whoops. If you go to my channel, this is my YouTube channel right here, the dashboard, and this is the content. So here we go. Declaration of Independence. Organic Law, Part 3, Declaration of Independence. Nelson. There's a bunch of them here.
Right. So just I like when on your website you put things in order, you name them.
Right,
That
yeah.
helps people follow a
It's
procedure.
easier to find it on the
because You
website.
and I know maybe what happened during those, but it's
Right.
So it's for future. Not that we want to have more work for you.
Yeah. Well, a lot of my recent videos, none of them have been added onto my website. I need to contact my webmaster, and
And maybe when you turn, how you title the different videos, like Declaration of Independence, that was good. And then organic laws.
right.
Like I think we've discovered now that those are critical to the appealable issues as well, is who we are as sovereign citizens.
Right. So Lenny Malley wants to know, do they not have to bring forward the accuser? Absolutely they do. If you're a U.S. citizen, they don't. But so you stand your ground, you demand it, and they're presuming that you're a U.S. citizen. So you get it on the record that you've a demand for a writ of demand to face your accuser. And so I would that'd be something to file into the case. Again, to build a case of denials of due process of law, and all the rest of it. That's a great point.
I think, Glenn, what I was missing when I did the notice of demand, I would change it to writ, and I would make sure I signed it and sealed it personally.
Right.
I forgot to sign it. He could say in his mind as the judge, well, you don't know what you needed to do, so I'm going to deny this, but he wouldn't tell me why he felt he could.
Right.
As opposed to
No, they won't. They won't.
To me, ordering him to do something with proper and lawful authority.
Right.
That's going to change the tune.
So that's why you have to get everything in writing.
So in Lenny's case here,
And you cannot put without prejudice by your signature on a document that you want to have power.
right, and that's critical to understand.
And I've seen people do that all the time, and it's a major mistake. They get railroaded too. And they wonder what happened. They say the courts are corrupt. Well, actually, you went and nullified your signature by putting without prejudice there.
Right. So on a writ, my plan now is to author a writ as a sovereign, as a state, a small s, and order the judge to do what I want him to do.
Right. I think I'm going to add that in up here.
Oh, the anointing likes that. Go ahead. First time today I've been getting it, so it took a while.
114. Writ of demand to face my accuser. So then we'll go back to 114.
Apart from the knowledge, it's always the state against. So.
Right, which is why.
That's why they have to produce it. That's
But we go in. We're not signing anything. There's no authority in the courtroom. We're there physically.
it's all a big charade. You're exposing the fraud.
Right.
Yeah.
It's Roman law.
That's
Okay,
right.
they're not interested in justice.
Yeah. So we have to come in and force their hand.
So yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of clergy, to be bound in conscience to account to assess the use for the rents and emoluments of the estate. That's taxes, folks. And isn't it convenient that the Roman cult gets to decide whether it's lawful or not? And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And use is short for usufruct. And that's taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And again, this minor estate is an act of Congress respecting an establishment of religion, and that's unconstitutional. They routinely unlawfully arrest you with the objective of you exercising your right to resist their unlawful arrest with military police pigs, so you can have an excuse to murder you. So the military police pigs can have an excuse to murder you. They're engaging in their endless wars to get you into their killing fields. Either way, their bankster handlers can pillage all the fake money and from the Treasury direct account. This is all about the minor estate and the Treasury direct account. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. And that's the causes and necessities for taking up arms, 1775. So, again, martial law supersedes and replaces common law, and so you cannot mix it. You absolutely cannot mix it. Under Title I, Section 1, it says that incompos mentis means insane. And so that's why they tell you, if you have a good judge, he'll tell you you're crazy, you don't know what you're talking about, I'm going to have you sent to a mental institutions to have your head examined. So he's telling you that you don't know what you're making bad arguments. And so that's a good judge. The other judges, they'll just sit there and play stupid and they won't say anything and rule against you and let you figure out what happened. That happens all the time. Anyways, so it's all dictatorship. It's plenary. Remember, they're talking about it plenary. You're denying a trial by jury. The War of Independence was fought over the denial of a trial by jury, and that needs to be brought up in these cases where you're demanding a trial by jury. The War of Independence was fought over the denial of trial by jury, and it's a dictatorship. That's what a despotism is. It's a dictatorship. It's plenary power, and that judge, he wants to make a bunch of money. Okay, that's what's happening. He gets money for issuing a warrant of arrest. This is found in the Judicial Code, the Code of Law for the not the Judicial Code, the Code of Law for the District of Columbia. And so 31 Stat 1366, he gets money for issuing a warrant of arrest, which is a capias, a fake warrant. So then he's getting paid. Issuing a commitment, when they sell you into slavery, that's a commitment. And so he gets money to sell you into slavery, drawing a bond, administering an oath, transcripts. That's why the transcripts are so damn expensive, because the judge is getting his piece of the action. Yes.
I would suggest next time put all those words in capital letters because it explains the style, the maritime aspect, just to help people understand more. Should say complaint, warrant, commitment, subpoena. Everything's always in capital letters on those pieces of paper that I have seen, and that's how I figured out how to defeat this current warrant, because it's in capital letters and it's a maritime and he has no jurisdiction.
I think in the original code, I think it's not in capital letters.
Interesting. Well, then, okay, we'll have to investigate. Maybe it wasn't, because, but slowly but surely, they're extending the courts of admiralty and vice admiralty far beyond their ancient limits.
Right, no doubt about
So
that.
they're just getting worse and worse in their obvious betrayal of the Constitution.
Well, putting it in all block capital letters is shouting it to you. It's trying to bring it to your attention for sure. And so I don't see, again, yeah, it's a fiction. At common law, nothing's spelt in all block capital letters.
Correct, which is why when you're, we do have to investigate how it's written, number one. But as far as today goes, whether they're being paid through 31 Stat 1366 or some other DC code.
Well, they've changed it. I mean, there's been amendments. Back then, I think it was like 50 cents or $1 or $1.75 or something like that, $1.50. But that was number one. That was lawful money, number one. And that's when lawful money was worth something. $1 a day was a man's labor. A man would get paid $1 a day to work. And so that's a day's work for a lot of people,
Can you pull up Amendment 7, please?
Well, let's see. Amendment 7, eh? So, Bill of Rights. And we'll go to the National Archives right here. No person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising on the land, in the land or naval forces, or in the militia, when an actual service.
No. This is the original. Those are, you have to, meaning that was what was sent out to the states. Let's go down and look at what they approved. See the difference? There you go. This is the Bill of Rights. There you go.
Okay.
Now, what do you...
In suits of common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
What I wanted to point out is the lowercase aspect of $20 and right of trial by jury.
Well, they're both lowercase, yeah, for
which
sure.
is common law.
Right,
So the silver dollar, the dollar was common law money
right.
at that time. So I'm not sure that, and the word controversy there is lowercase, but the word suits is capitalized.
It sure is, yep.
So what all that means, we can decipher, but I just wanted to bring it to your attention, Glenn, that because you were referring to dollars.
Right. Well, I don't have the fee that they're collecting because I know it's changed. And that's why I didn't put the fee down here, because it's changed. They've changed it since then. They've changed it probably numerous times.
Okay, but so today they're drawing a complaint, they're issuing a commitment, but what they're issuing is not under 31 Stat 1366.
Sorry?
Is it under 31 Stat?
Of course, that's why I put it there.
Then they're not. That's not what's on the page. They're not issuing. I'm going to look up 31 Stat 1366.
It just says that they get paid a royalty for issuing a commitment. It says a bunch of things. It's a whole page. I mean, I can pull it up here. I think I've got the DC code in my files.
Yeah, let's do it. I want to see what it actually says. how it's styled, because that's even worse for them when they're violating. But didn't sometime at some point you said something was in 1901 or 19 something, 1900s.
There we go.
Let's see what year.
So we're talking 1366,
Yeah, March 1901.
1190. So it's going to be down here a ways.
And that makes some more sense because they were starting to bring in so they're adding to the code.
1228.
Whereas this
See, this thing's going to start crashing, and I can't disconnect from the internet because it's this fucking Adobe. I can't, it'll crash every time until I disconnect from the internet.
Let's not do it then. We'll review it later. 31 steps.
Anyways, so we'll look it up later.
Yep. Thank you.
I'll suggest another reader for you.
Well, it's Adobe Pro. It allows me to manipulate the files. I can sit there and take pages out. I can add pages. I can do all sorts of stuff. And so not every reader will do that.
No.
And that's why I have Adobe Pro. But it's an older version, and it wants to update. And I bought it on eBay, and I think it's a bootleg version, and so it won't update, and so then it just crashes. Until what'll happen is if I disconnect from the internet and then I have Adobe open for a while and keep it open, and then when I reconnect, it won't crash anymore. And for some reason, I'm not exactly sure why. But so the bottom line though is that I went and rebooted my machine last night, and so everything's fresh, and so it crashes until I have it open without it being online for a period of time. It'll crash. Penitentiary has meant a penitent, an ordainer of penitence, penances, a place for penitence. See, this is the Roman cult again, and that's Anderson Law Dictionary 1889 edition. Penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied for pious uses. Okay, usufrux. This is a Roman law, Roman cult. And so Trump commuted Roger Stone's sentence. What he did is he paid off the Vatican. And so it's all coming from the Vatican. This is all Roman law. It's the Vatican. Don't get me going. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. Original assault rifle was the musket, was banned from import in 1774. In 1775, the British attempted confiscation, and in 1776, revolution. When liberty and freedom are at stake, your silence isn't golden, it's yellow. They want you dead. I didn't say it would be easy, I said it would be the truth. Rebellion to tyrants is obedience to God. It's time to get unplugged. We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience has shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they're accustomed. But when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under absolute despotism, that's dictatorship, folks, it is their right, it is their duty to throw off such government and provide new guards for their future security. And that's Declaration. This is the preamble for the Declaration of Independence, 1776, the organic laws.
And by the way, that doesn't mean every 4 years or every 2 years when it's time to vote.
Yeah, no joke. You got that right. Yeah, you got that right. And so, yeah, exactly. So again, you have to understand that the whole purpose of any court case is to sell you into slavery. These Roman cults, Satanists, want to sell you into slavery. And if you're in their so-called court, then it's warfare. And it has to be all out, knock down, drag out war. And you sabotage them, you do everything you can to break it off in their ass and make it so that they don't ever want to talk to you again. And that's the only thing you can do. They are your enemy. You are their enemy. And the sooner you get your head around that, the better. And break it off in their ass. Let me, I'm going to PDF this. Maybe that PDF will stay open. Sometimes they do. And we'll start the next one. We'll take a 5-minute break so people can go potty and things. And then we'll just keep going. And that way, we've already gone through lunch. We'll just keep going. What?
I just need you to reiterate the commitment. The judge is getting commitments 31 stat.
Yeah. Let me see if this stays open.
1366.
This might stay open. Oh, no, see, it crashed. 31 stat, 1361, I think.
1361.
1366. I think it was 1366. So the next one is it's political. So anyways, yeah, the next one is it's political. We'll start through this one. I don't think we'll get through the whole thing. We'll go to about 5 o'clock and then we'll cash it in. Right now it's what, about 2:15. So we might get through it all. Actually, what I should do is stop the live stream and stop recording and then start a new one. Okay, everybody on YouTube, I'm going to stop the live stream and then start another one here in a couple minutes for this new presentation. So come back. We'll be back in about 5 minutes. Okay.